it is not on records. May call for the records. Dusty service. Okay.
Call for.
May I please, my lord, I beg to mention item number 6, my lord. My lord, kindly adjourn for the day, my lord. We have some difficulty.
Heard, Mr.
K. Uddin, my lord.
K. Uddin, learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty of the conducting counsel. The prayer is allowed. Let this matter be listed after a week.
Next week. May I please, your lordship.
I beg to mention item number 43, Lordship. The matter may be adjourned, Lordship. Leading engaged counsel B. Bora was not keeping well. Listing after 2 weeks, Lordship.
43.
Item number 43.
Heard, Mr. What is an
Dekar.
G. Dekar, learned counsel for the.
Respondent number 1.
You have informed the. You have been.
We have not informed.
You first inform. Thereafter make.
We will
mention.
inform them.
No, you first inform. Thereafter make mention.
Lordship.
It will back to mention item number 12, Lordship. I'm for respondent number 1, Lordship. I want to withdraw from the case, Lordship. Kindly allow me to withdraw my wakalat nominate.
You send the notice to the respondent and submit that
Lordship.
you follow the procedure of withdrawal.
Lordship, I beg to mention for listing of a civil revision petition on Friday.
Court number 14,
Court number 14.
senior court.
Okay. May I please, Your Lordship, I beg to mention item 12. We are for the petitioner. So kindly adjourn this matter for this week as the engaged counsel, Mr. S.Z. Raymond, is out of station. We have taken the consent.
Okay. What is your name?
Ilitishi.
Heard, Miss Learned Counsel for the petitioner who prays for an adjournment on the ground that conducting counsel Mr. S.Z. Rahman is out of station. Learned Counsel for the petitioner has submitted that she has obtained the consent of the counsel for the respondent side, who has no objection to her prayer. Considering the submissions, the prayer is allowed. Let this matter be listed after a week on a date to be fixed by registry.
May I please, Your Lordship? I beg to mention item number 9.
9.
Item number 9.
Yes.
Due to health issue, my senior counsel R. Bora could not come. Matter may be fixed on
Heard, Mr.
R. Bora.
What is your name?
S. Uddin.
S. Uddin,
On behalf of R. Bora.
who submits that the conducting counsel for the petitioner, Mr. R. Bora, is indisposed, and on that ground he prays for an adjournment. The prayer is allowed. Let this matter be listed
Understood.
after in the next week on a date to be fixed by registry.
Understood.
May I please, Your Lordship, kindly matter of taken after some time. Senior counsel in this is another court here. Item number 2. What is the?
Today it is fixed for status report. Lordship, the co-accused has already been announced on bail. I've been behind number for 1 year, 7 months, 8 days. Today itself, Lordship. Till that, not a single witnesses has been examined. The order, co-accused order is page 33.
What is the status?
Lordship, till that, not a single witness has been examined. Lordship.
Yes, Mr. Kaushik.
Lordship, status report I didn't go through, Lordship. Maybe it may be received, Lordship. Fine.
The last order is Lordship 8-7, Lordship. 8-7, last order is 8-7, Lordship. It is stated the relevant person. Today the matter is fixed for prosecution evidence. However, no witness is present as prosecution has failed to take steps. Like this order, there are 3 consecutive orders under similar circumstances. However, Lordship, co-accused has been enlarged on bail.
Who is the? How many witnesses are there?
Lordship, Lordship.
Lordship,
Eight witnesses.
8 witnesses.
Out of it, not a single one has been examined.
What is the date of your arrest?
Date of arrest is the 18/12/2022.
Yes, Mr. Bosho.
Lordship,
No way out.
yes.
Heard Mr.
PK, sir.
P.K. Sohria, learned counsel for the petitioner. Also heard Mr. K. Bosho, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure. This application under section 483 of the BNSS, 2023 has been preferred by the petitioner, namely Maidi Doimari, who has been detained behind the bars since 18/12/2022, within bracket, for more than 1 year, 7 months, in connection with NDPS case number 74/2024, corresponding to Hathigaon PS case number 573/2022. Under section 20C/20B2C/29 of the NDPS Act, 1985, which is pending in the Court of Learned Additional Sessions Judge number 3, Kamrup Metro, Guwahati. Quote para 3 from page 34. Quote para 4. Learned counsel for the petitioner has submitted that in the instant case, the co-accused, namely Gopal Basumatari, has already been granted bail by this court on 26/6/2024 in bail application number 1439/2024 on the ground of prolonged incarceration. Stop. Learned counsel for the petitioner has also submitted that though the petitioner has been languishing behind the bars for more than 1 year, 7 months, and though the charges were framed on 5/1/2024, however, till date, not even a single witness has been examined. Stop. Quote para 6 from page 35. Quote para 7, 8, 9, 10, 11, 12. It appears from record 11, 12, 13, 14, 15, 16, 17, 18, 19, 20. In the instant case also, from the facts and circumstances discussed herein above, as well as in the light of observations made by the apex court in the ruling cited herein above, comma, this court is of considered opinion that the long incarceration of 1 year, 7 months without there being even a single witness examined, comma, the comma outweighs the embargo of section 37 of the NDPS Act, comma, 1985. In this case, no. কাটি দিব, এই paragraph কাটি দিব again. In the instant case, from the facts and circumstances discussed herein above, and in the light of observations made by the apex court in the ruling cited herein above, this court is of considered opinion that in view of the long incarceration of more than 1 year, 7 months already undergone by the above named petitioner, and in view of the fact that not even a single witness has been examined, comma, the fundamental right guaranteed to the petitioner under Article 21 of the Constitution of India outweighs the embargo of Section 37 of the NDPS Act 1985 in this case, and as such, the above named petitioner is entitled to go to get bail. In view of above, the above named petitioner is Court Para 22, Court Para 22, same. 50,000 with 2 sureties of like amount.
Deeply obliged.
May it please your lordship. Lordship, this is a petition challenging the order of non-granting of injunction, your lordship. Lordship, the basic facts, your lordship, just the background. The plaintiff is the son of one Shambhu Thakur, who is the
Which court denied in
both
injunction?
the courts, the appellate
The
court.
trial
and
court as well as first appellate
First
court. We're issuing notice. Heard, Mr. What is your name?
B.J. Mukherjee.
B.J. Mukherjee, learned counsel for the petitioner. Stop. This application under Article 227 of the, whether it is under 227 or whether it is under 115,
227, your lordship.
it cannot be under both.
227.
Under Article 227 of the Constitution of India, impugning the order dated 22/4/2024 passed by learned Civil Judge Senior Division Kokrajhar in Miss Appeal number 4/2023, whereby it upheld the order dated 29/9/2023 passed by learned Civil Judge Junior Division Kokrajhar in Miss J case number 17/2022 arising out of title suit number 13/2022, whereby the prayer for grant of temporary injunction by the present petitioner was rejected. Issue notice to the opposite parties and call for the case record of Miss Appeal number 4/2023 as well as Miss J case number 17/2022 from the concerned courts. The petitioner shall take steps for issuance of notice by usual mode as well as by registered post with AD within 3 days from the date of this order, returnable on 22 August 2024. List accordingly.
My pleasure, Lordship. I'm sorry, Lordship, I was late on court number 18, Lordship. But in this case, Lordship, the petitioner is a Mason, Lordship, and one advocate and some other person, and they.
Yes, there is there.
Yes, Lordship. Yes, that is received.
Lordship, and he's working under them, Lordship, and construction, Lordship only.
Who is the petitioner?
Simon Boro, Lordship.
What is the offense?
Offense land grabbing, Lordship, and the broker, Lordship. Okay, FIR will find page number 8, Lordship. And 11 operating person, page 12,
No, offense is under section forgery,
Lordship.
trespass and
68, 467, 120, 447. And 45 days as on today.
what is the progress?
See, progress is going on. Right, Lordship, may kindly aware of about this case. It is all the land grabbing, the whole racket, the people are involved. Here, Lordship, in this.
No,
matter
but this
also-
is not land grabbing case. This is a case of,
But Lordship, here, his involvement is there in the entire part. I have flag marked some portions there, Lordship.
but allegation is of forgery.
Yes, for that, because.
Regarding forgery,
Yes,
what
there's
is
a
the?
team is involved, entire team is involved, Lordship, in this matter. And he was shown arrest, Lordship. He was shown arrest.
And send the two case.
The original arrest was made on which day?
324 Gorsuk case, and this is on 325, Lordship, same day. Shown arrest. And otherwise, Lordship, the petitioner, we had, he's a lettered person and he cannot be do any forgery, but because he is a Mason by profession, I'm very categorically made statement in my petition. You should find case number Lordship,
Whether his custodial detention is required
45.
after 45 days. You want his to interrogate him or not?
Even then, Lordship,
Lordship is interrogation, only Lordship, one part, Lordship, just that part only, Lordship. Kindly see. Right, Lordship.
Which part you have?
Lordship, I have flag marked only that page, Lordship. The co-accused statement, Lordship, it is the entire interrogation.
What is your name?
Simon Boro, Simon Boro.
Simon Boro.
Okay. When to forcefully possess the land.
Lordship. But before that, Lordship, that all the other parts are there. Connected team, Lordship.
He'll appear
Lordship.
He will appear before the IO every week for 2 weeks. Heard Mr. F. Hawk, learned counsel for the petitioner. Also heard Mr. K. Basho, learned additional public prosecutor. This application under section 483 of BNSS, 2023 has been filed by the petitioner Simon Boro, who has been detained behind the bars
9/6/24.
since 9/6/2024 within bracket for last 45 days in connection with Gorsuk PS case number 325/2023 under section 120B/467/468/447 of the Indian Penal Code. The gist of accusation in this case is that on 1/12/2023, one Sudipto Goswami had lodged an FIR before the officer in charge of Gorsuk police station, inter alia alleging that some miscreants have illegally entered into the landed property of the informant and forcefully dispossessed him. It is also alleged in the FIR that that three accused persons involving the present petitioner have been specifically named in the FIR to have produced fake documents regarding the land rights. It is alleged that the petitioner, along with other co-accused, tried to illegally grab the land belonging to the informant. Learned counsel for the petitioner has submitted that the petitioner is a Mason by profession and the allegations leveled against him in the FIR are not true. It is also submitted by learned counsel for the petitioner that the petitioner has been detained behind the bars for last 45 days, and considering the period of length of detention already undergone, he may be allowed to go on bail, and he is ready to cooperate with the investigation, with the investigating officer. Stop. On the other hand, learned additional public prosecutor has produced the case diary of Gorsuk PS case number 325/2023 and has submitted that there are incriminating materials against the present petitioner in the case diary involving the statement of the co-accused, wherein the co-accused has implicated the present petitioner. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the materials on record, including the case diary of Gorsuk PS case number 325/2023. Though there are some incriminating materials against the present petitioner in the case diary, however, considering the progress made in the investigation as well as considering the period of detention already undergone by the petitioner, this court is of considered opinion that his further custodial detention may not be necessary for fair completion of the investigation in Gorsuk PS case number 325/2023 if he cooperates with the investigation. Stop. In view of above, the above named petitioner is allowed to go on bail of ₹30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Kamrup Metro with following conditions. Number one, the petitioner shall appear before the investigating officer every week for next 2 weeks or till the investigation is completed, whichever is earlier. Number 2 and 3, this bail application is accordingly disposed of. Send back the case diary.
Lord, the petitioner before your lordship had obtained an injunction order in a partition suit. The operative portion of that injunction order, your lordship finds it at page 47.
Page 47.
Page 47. That's the operative portion of the injunction in my favor.
What is it?
It's dated 22/3/23, restraining the opposite parties from transferring, alienating, encumbering, changing the nature and character, as well as creating third-party rights to the properties described in Schedule B to the instant application, as well as restraining the opposite parties from changing, altering the shareholding of Bonomali Tea Estate Private Limited in any manner whatsoever till disposal of the suit. Now, alleging violation of this particular order, we initiated a proceeding under Rule 2A. And that application is on the following page, my lord. Our basic allegation was that notwithstanding the order of injunction, certain new tenants were inducted in the house standing on the Schedule B property.
Okay.
Now, my lord, to that, my lord, to the violation application, my lord, they filed a written objection, which your lordship finds at page 58.
Page 50,
58.
58.
58.
Yes.
Now, my lord, the stand of the opposite party basically was that they admitted that there are third parties in the house, but they said that these people we've inducted way back before 2017. Now, to substantiate their defense, they annexed a number of agreements across 4 or 5 years to show that they were there from before. It's merely a renewal. Now, after this objection was filed, we out of curiosity, we checked the documents and we found something very intriguing. If your lordship may kindly take up page 89.
Yes.
89, my lord. This is an agreement for leave and license dated first day of September 2019. Now, at page 96, 103 and 111, your lordship will find similar agreements of the subsequent years. Now, if your lordship may mark the serial number of the stamp paper, your lordship will find that it's a running serial number for all the deeds, for most of the deeds, which were shown to be executed year after year.
Next deed is at
page 96. This is of 2020. Next, thereafter at page 103 of the year 2021. But intriguingly, there's a running serial number.
now what is this number?
This is the stamp paper number. So, my lord, our apprehension, our basic ground was that these documents have been made backdated only to substantiate their defense that the tenants were inducted prior to the order of injunction.
Okay.
Now, my lord, after this, my lord, we, since our allegation was that you must produce the flip side of the stamp paper from where we can figure out as to on what date it was actually issued, my lord. Now, therefore, we filed an application under Order 16, Rule 6 to call for the original of those documents. Because your lordship is aware it's a violation proceeding, it's quasi-criminal. I must prove it by way of evidence.
Okay.
My application is at page 117, where I sought these documents. I pointed out the discrepancies that though these have been shown to be executed year after year, it is on serial stamp papers of the same date and period, and therefore the original should be called for. Now, page 117 is my application summoning those documents, my lord. And at page 123, your lordship will find the reply. Something.
Yes.
Just one paragraph at page 125 from the objection filed to the application seeking production of those documents, my lord, is at para 5, page 125. Para 5, page 125. This is their response, my lord.
Okay.
Then paragraph 5 of the petition, the petitioners have referred to running serial number of non-judicial stamp papers that the agreements are not notarized and alleged that the agreements were executed subsequent to the passing of the injunction order. It is submitted that in the year 2019, the COVID pandemic started, which continued for the succeeding years, as OP defendant number 1 is of advanced stage and is a cancer survivor, it was not possible to execute fresh grant of license to the licensee during the pendency of the pandemic. Therefore, the existing licensee Samrat Deka was granted verbal permission to continue as the licensee, and it was agreed that for record keeping purposes, the license agreements would be executed once the pandemic was over. Thereafter, in the year 2022, the opposite party secured non-judicial stamp
So
papers and executed.
they admit.
They admitted. So they did not have any way out. They did not want to produce the document. So they sort of admitted that this was during the pandemic. We had actually executed backdated agreement. Now, in the application where I had sought production of the original, the impugned order was passed, and that order, Your Lordship,
You
finds
are
that
impugning the order. What was the order?
the prayer to call the documents was declined.
But they are admitting.
Manoj, they're admitting, but the problem is the reasons that are cited, Manoj. If Your Lordship may come to page 175, part of the impugned order.
170.
5.
Yes.
Manoj, the third para onwards, all the documents.
Yes.
All the documents in the list of the OPs are documents of leave and license agreement of different dates ensued since 2017 prior to institution of title suit so and continuation thereof till 1622. In his argument, so for the OPs have rightly pointed out that the petitioner has incorrectly referred to license agreements as lease agreements. Perusal of the documents make it clear that neither of the documents listed by OPs refer to granting lease of any property. The operative part of the order dated 5/4/21 that the petitioner prayed for an ad interim temporary injunction restraining the OPs from transferring and or alienating the properties described in Schedule B5 to the plaintiff till disposal of the injunction application, that is Miss case so-and-so, also explicitly speaks the petitioner did not have prayer for restraining the OPs from granting license. The entire discussion makes out that the aforesaid documents are irrelevant for disposal of the issue of violation. Well, it digresses to something totally different, my lord. The trial court says that these are merely leave and license agreements. Now, what the trial court has essentially done, in my respectful submission, it has prejudged the issue of violation by holding that these are license agreements, therefore it doesn't come in conflict with the order of injunction, my lord. Secondly, my lord, the order of injunction was very wide.
What is the difference between license
And exactly that was the third point, my lord. Just by the nomenclature, you cannot determine the document itself, my lord, whether it's a transaction of license or lease. If Your Lordship may kindly have this. In fact, there are a number of judgments where the Supreme Court have held. Para 8 and 9, if Your Lordship sees. This was
Para?
para 8 and 9.
Yes.
This was based on the earlier judgment of Associated Hotels, which described the distinction. And para 9 is very important, my lord, of that. If I made 8, my lord.
Read. Please read.
Yes, my lord. 8 onwards, I'll read, my lord. The crucial issue for determination as to whether there is a lease or a license existing between the parties, though a deed of license may have been executed, it is open for the parties through the document to show that the relationship which was agreed upon by the parties and was really intended to be brought into existence was that of a landlord and tenant, though it was outwardly styled as a deed of license to act as a camouflage on rent control legislation. Lease is defined in section 105 of the Transfer of Property Act, while license is defined in section 52 of the Easements Act. Generally speaking, the difference between a lease and a license is to be determined by finding out the real intention of the parties as decipherable from the complete reading of the document, if any, executed between the parties and the surrounding circumstances. Only a right to use the property in a particular way or under certain terms given to the occupant while the owner retains control or possession over the permissive results in a license being created. For the owner retains legal particular purpose or in a particular manner, but for the permission so given, the occupation would have been unlawful. The decided cases on the point are legion. For our purpose, it would suffice to refer to the decision of Corporation of Calicut versus so-and-so. Para 9, my lord. A few principles are well settled user of the terms lease or license, lessor or licensor, rent or license fee are not themselves decisive of the nature of the right created by the document, an effort should be made to find out whether the deed confers a right to possess exclusively, coupled with the transfer of a right to enjoy the property, what has been parted with is merely a right to use the property while the possession is retained by the owner. The conduct of the parties before and after creation of the relationship is also of relevance of finding out their intention. So, my lord, without an inquiry, just because the documents were styled or titled as leave and license agreement, the trial court ought not to have jumped to the conclusion that there has been actually no violation of the injunction. And that too in an application under Order 16 Rule 6, my lord. It has virtually decided violation in their favor,
To a applicant.
my lord. That's,
Now what do you want?
Lord, notices should go, my lord. I'm just praying for the stay of the violation proceedings, my lord. My lord, since it is apparent that the court has made up its mind.
No, but violation proceeding was initiated
by
on
me.
your behest.
Ma'am, on my behest, my lord. But until this issue is resolved, my lord.
Okay. Heard Mr. B.D. Deka, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioners, namely 1, 2, 3, 4, and 5, impugning the order dated 28/3/2024, passed in Miss J case number 22/2023 in connection with title suit number 7/2021, whereby the application filed by the present petitioner under Order 16 Rule 1 and 6 of the Code of Civil Procedure, 1908 was rejected. Issue notice to the respondents. The petitioner shall take steps for issuance of notice to the respondent by usual mode as well as by registered post. The notices are returnable after 1 month. Whether we have to call for the records, everything is there.
Everything is more or less here, my lord.
Okay,
Originals
okay.
they have been produced.
Okay. In the meanwhile, considering the nature of issue involved in this revision petition, further proceeding of Ms. J case number 22/2023, which was initiated at the behest of the present petitioners, shall remain stayed. List accordingly.
Deeply aware. Lord, will your lordship clarify that the title suit may proceed?
Oh, yes. It is hereby clear, it is however hereby made clear that the title suit number
7 of 21.
7 of 2021 shall proceed in its usual course.
Obliged.
Lordship. This revision petition is filing for the correction, modification and enhancement of the stipulated amount of the maintenance as indicated in the impugned order dated.
You have to be louder. Mic is okay. You have to be little louder.
This revision petition is filed for the correction, modification and the enhancement of the stipulated amount of maintenance,
Okay.
which is indicated in the impugned order 4/4/24.
Okay, how much was granted?
7,000. 7,000. 7,000 to the respondent and 1,000 for the litigation cost.
How much do you want?
At least 10 to 12,000.
Okay, we're issuing notice. Heard Miss, what is your name?
They
Heard Miss M. Day, Learned Counsel for the petitioners. This application under Article 227 of the Constitution of India has been filed impugning the order dated filed by the petitioner Srimati Priyanki Bora, impugning the order dated 4/4/2024 passed in Ms. J case number 29/2023 arising out of matrimony MAT within bracket D case number 57/2023 by the learned additional district judge number 3 Nagaon, whereby the respondent was directed to pay an amount of rupees 7,000 per month as pendentalite maintenance and rupees 1,000 as the cost of litigation. The petitioner is aggrieved with the quantum of the said pendentalite maintenance and has prayed for and is praying for enhancing the said quantum. Issue notice to the respondent. The petitioner shall take steps for issuance of notice to the respondent by registered post with AD as well as by usual mode within 3 days from the date of this order, returnable after 1 month, list accordingly.
Please.
My opinion.
Yes.
But in this case, the petitioner before your lordship, he was a defendant in the title suit.
Defendant in the title suit.
Titles
Okay.
instituted by the sole respondent in this case. Notice issued, he received notice. After receiving notice, he appeared and filed obligations. Thereafter, he is a 76 years old man. Because of his various ailment, he failed to appear before the court.
Defaulted.
Under such circumstances, the trial court ought to have proceeded the case in view of Order 17 Rule 2, but that did not done. And it was proceeded as if it is a contested suit. And finally, the suit is decreed against the present petition. Since the petitioner was suffering from various ailment, he
It
also
was decreed as a contested.
as if it is a contested suit. The decree, though it ought to have been proceeded under Rule 17 Order 2, but it was proceeded as if it is a contested suit because he filed obligations. Subsequently, after decree, because the present petitioner, he was suffering from ailment, he could not approach the appellate court or Order 13 Rule 9 petition, Order 9 Rule 13 petition in time. And he preferred appeal with a condemnation of delay petition. The appeal is pending and the appellate court has issued notice in condemnation of delay petition. There is no stay. In the meantime, execution proceeding started.
Okay.
Since there is no stay in the appellate court, only notice issued in the limitation petition, I filed an application before the executing court for stay of the execution.
Before the executing court.
Before the executing.
Okay.
That was rejected by the imping order. Your lordship will find imping order is at page 16. Page 16.
I had got it, page 16, 1/6. Here the ground that I have not furnished any stay order,
Page 16.
1/6. On that, since no stay order was furnished, it was rejected. Case record is put up today on the strength
You
of
could
petition.
have prayed for stay before the first appellate court also.
Because as per the, my lord is well aware, as per the procedure, once a appeal is filed with a condemnation of delay petition, normally appeal is not numbered. Only condemnation petition is.
Okay.
So since appeal is not numbered, so stay petition has not been considered, only notice issue. So under such circumstances, finding no alternative, I filed this because the trial code, the executive code has the jurisdiction in view of 21,
Yes.
order 21, rule 26. That, and there is a law settled, my lord, there is some case laws are also there.
But why you defaulted?
Defaulted because of my ailment, my lord, that I have stated. Since
Then you filed
the case was fixed on auto for order on 31/7/24, next 31st July,
you have preferred an appeal
appeal.
against the decree and
The
the
Ex
judgment.
parte degree, it is
Ex
an
parte.
ex parte degree.
But it is not shown as an ex parte.
Not, it is shown as an contested suit because WS is filed. So under such circumstances, my lord, since on the date of my lord, my petition was turned down, I approached this court. I filed the present petition. Pending the case yesterday, what they did, my lord, my degree is executed, my house is demolished. I have been thrown out from this.
Oh.
So, though we brought it to the notice of the officials who come to execute the decree, my lord, they did follow it because there is no order. So, though the question of law is alive in this case, in fact, the matter become infructuous.
Infructuous.
So, in that, under such circumstances, may I, my lord, pray, my lord, your lordship will be pleased to close this matter with an observation that in the event, my lord, 140, under section 144 CPC, that I may be
Restitution.
restituted.
That,
In the event of my
no,
appeal is success.
no, but that order has to be passed by the appellate.
Observation, the petition has the
No.
liberty.
That in law you are entitled if
Yes.
that is the matter to be dealt with by the first appellate court.
If
We are only closing this matter.
this observation is there, my lord, it will have.
No, we don't know the facts, only
Well, I am not saying that only the observation, in case in case I succeeded in the appeal,
no, that
I
is-
had the
that would not. be-
remedy under law.
Remedy is always available under law for that observation.
What I leave to your lordship.
Now you are withdrawing this.
Instead of withdraw, your lordship, my lord, may close it because some professional bindings are there.
Okay. Heard. Mr. A.I. Uddin, learned counsel for the petitioner. This application under Article 227 of the Constitution of India, read with section 151 of the Code of Civil Procedure, has been filed by the petitioner Muhammad Noor Islam, impugning the order dated 4/7/2024, passed by the executing court, within bracket, the Court of Learned Munsif number 2, Nagaon, in title execution case number 11/2023, whereby the executing court had rejected the petition number 1784/2024 filed by the petitioner/judgment debtor, praying for ad interim stay of the execution proceeding in the execution case during the pendency of the appeal, which has already been preferred by the present petitioner against the ex parte judgment and decree dated 18/3/2023. The facts relevant for consideration of the instant revision petition is that the respondent had filed a title suit before the Court of Learned Munsif number 2, Nagaon, for declaration of right title and interest and recovery of khas possession of the suit land, which was registered as title suit number
52 of
52 oblique 2012. Stop. Learned counsel for the petitioner has submitted that though the present petitioner who was the defendant in the aforesaid title suit had appeared before the trial court and had filed his written statement. However, thereafter he defaulted due to his old age and ailment. And the trial court it is submitted by learned counsel for the petitioner that the trial court ought to have proceeded under Order 17, Rule 2 of the Code of Civil Procedure. However, instead of that, it proceeded in the trial as if the trial is proceeding normally, and ultimately decreed the suit against the plaintiff. Stop. The plaintiff preferred a title appeal against the decree so passed by the trial court before the Court of Learned District Judge,
Civil Judge Senior Division.
Civil Judge Senior Division, Nagaon. However, as there was a delay in preferring the first appeal before the said court, the petitioner had also preferred an application under Section 5 of the Limitation Act 1963 for condonation of the delay in preferring the first appeal. It is submitted by learned counsel for the petitioner that the First Appellate Court had issued notice in the miss case, notice to the opposite party in the miss case relating to condonation of delay petition. In the meanwhile, as the execution proceeding, as the execution case was filed before the executing court, the present petitioner had filed a petition which is numbered as 1784/2024 before the said court for stay of execution during the pendency of the appeal, which has been preferred by the present petitioner. Stop. The said petition was, however, dismissed by the executing court on the ground that there is no order of the stay passed by the First Appellate Court. Stop. And this instant revision petition has been preferred against the said dismissal order dated 4/7/2024, passed in title execution case number 11/2023. Stop. Learned counsel for the petitioner has submitted that in the meanwhile, that is on
Yes, sir.
23rd July 2024, the decree has already been executed by evicting the present petitioner from the suit land and delivering the possession of the same to the judgment debtor / respondent. And therefore, the instant revision petition has become infructuous. In view of the submissions made by the learned counsel for the petitioner, this revision petition is closed on becoming infructuous with an observation that the petitioner is at liberty to seek any remedy to which he is entitled to before the Court of Learned Senior Division, Civil Judge Senior Division, before which the appeal filed by the present petitioner as well as condonation of delay application is presently pending. With above observation,
Oh,
this revision petition is disposed of.
obliged.
May I please, Lordship? Lordship, petitioner is debarred to file written statement. As because of.
90 days.
Interim order is at page number 26, Lordship,
20,
26. Stating that 90 days on that day it was 90 days. Twenty-six.
what is the case?
Case is for declaring title interest and confirmation of possession filed by the respondent. The present petitioner is the defendant.
Why you have failed?
I have failed. I have to obtain some authenticate certified copy from the revenue department, which I could not collect in the meantime. A possibility is that after 1 week, it will be collected. So I pray for time.
No, when will you file
Okay.
written statement?
I will file. Now we are able to file.
But you know the limitation is 90 days.
90 days, but at that day we are failed to collect the certified copy. So I am seeking at least 1 week time only.
What is the next date fix?
Next date fix is 6/8. 24.
File that with a cost.
Yep, of course.
Heard Mr. B. Fukun, learned counsel for the petitioner. This application under Article 227 of the Constitution of India, read with Section 151 of the Code of Civil Procedure 1908, has been filed by the petitioner impugning the order dated 13/5/2024 passed by learned Civil Judge Senior Division Kamrup Amingaon in title suit number 229/2023. Whereby the trial court debarred the present petitioner from filing the written statement in the aforesaid case. Learned counsel for the petitioner, Learned counsel for the petitioner has submitted that the respondents had filed the title suit number 229/2023 for declaration of right title and interest and confirmation of possession and other consequential relief as well as permanent injunction against the present petitioner. And the notices and the summons were received by the present petitioners in the said case. However, where have you mentioned the reason? However, the petitioners could not submit the written statement within the statutory period of 90 days as 90 days from the receipt of summons as some relevant documents are yet to be collected so as to enable the petitioners to prepare their defense in the said case. And accordingly, the petitioners had filed an application, filed a petition bearing number 1426/24 seeking further time for filing the written statement. Stop. The impugned order dated 13/5/2024 is quoted here in below for the sake of convenience. Quote from para 26. Learned counsel for the petitioner. Now whether you have collected the documents or not, when will you file?
We'll
You'll be able to file on 6/8.
6/8, better than 6/8. Any other
Bef-
date?
Before that,
6/8 after that.
no.
Oh, okay, 6/8 then. Then I will file within 6/8.
It appears that the trial court had rightly rejected. It appears from above that the trial court has rightly rejected the prayer for grant of additional time for filing written statement as the time prescribed under Order 8 rule. What rule? Rule 1.
Rule 1.
Rule 1 has already been completed since the date of service of summons on the present petitioners. Stop. However, learned counsel for the petitioner submits that now the petitioner has collected the relevant document and is ready to file the written statement on the next date fixed, that is on 6/8/2024, and therefore they may be allowed to file the written statement. So as to effectively contest this suit filed by the respondent side, subject to any condition which may be imposed by this court. Considering the nature of the case as well as fact and circumstances of this case, this court dispenses with the notices to the respondent side and allows the above named petitioner to file the written statement without fail on the next date fixed, that is on 6/8/2024, before the trial court, subject to payment of cost of rupees 2,000 which shall be deposited at the before the trial court at the time of on the next date fixed. The cost so deposited shall be given to the respondent / plaintiff by the trial court. It is hereby made clear that no further indulgence shall be granted to the petitioners by the trial court on the said next date fixed, and it shall be at liberty to proceed according to law if the petitioners fail to submit the written statement on the next date fixed. With above observation, this revision petition is hereby disposed of.
Blessed.
8. Okay.
Earlier, I filed one bail application with your lordship, my lord. In that case, my case was not registered, my lord. Your lordship was pleased to pass order. Case was not registered. Subsequently, same FIR has been already registered. That is only case, my lord. FIR, my lord, that is page 18, my lord. Lordship order is, my lord, there in page 20.
Now, what is the allegation?
Allegation same, my lord, same that which was not.
No, I don't remember.
Yes, my lord. Allegation is that, my lord, informant is the maternal auntie, my lord, of the petitioner number, maternal auntie of the petitioner number 1 and 2, my lord. Initially, my lord, both of them petitioner 1 to given shelter to her, my lord, and subsequently she wanted to my lord, sell a plot of land, and she wanted to stay separately, my lord. And amount was, my lord, deposited in the account of the petitioner number 1, my lord, and he has constructed 2 rooms for her. But subsequently, my lord, some dispute, my lord, female dispute, along with the, my lord, petitioner number 2, she wanted to stay separately. That is only case, my lord. Page 18. We requested.
Who is the informant?
Informant is maternal auntie of the petitioner number 2. Petitioner number 1 is the husband of the petitioner number 3.
Okay. Maternal aunt of petitioner number 2.
Yes, my lord.
And you, allegation is that you took 2,50,000 rupees.
Yes, my lord.
And you have not returned.
This amount.
Out of the said amount, you have written some amount.
Yes, my lord. Therefore, my lord, another allegation is also there. The amount of 15 lakhs, my lord. That is also mentioned here.
Where?
The last
15
part of
lakhs.
the FIR.
17 lakhs. 50.
Yes, 17
17
lakhs.
lakhs lots.
But actually, that is not correct. See, my lord, we have constructed one house separately for her, my lord. And due to the dispute with the petitioner number 2, my lord, she has separately, my lord.
So that's because the transaction amount is there and admittedly in the account of the petitioner. Okay, basically, maybe
This is
the reason
government
of the
employee.
city is required lots in this matter. To separate amount, one is in the bank transaction lots.
Already, my lord, she, my lord, informant herself requested me to keep this money because I did not, victim has not any account. And thereafter, he has constructed, I have stated paragraph 5, kindly period your lordship, paragraph 8.
Where is the earlier
Space. Earlier order is, lordship, I have annexed here.
at page?
Space, my lord, 20. Non, as case was not registered, not to take coercive action. Earlier also lodged one Ejahar, my lord, 7624, but it was not registered.
Whether police has recorded your statement or whether you have approached police or whether it is searching for you.
They are searching for, because my lord, as it was earlier not registered, that's why your lordship was pleased to pass interim order also there. Page 22. In my request, because in lower court also, my lord, we filed bail application without registration of the case. The lordship have mentioned everything in the earlier order. Till then, no coercive action shall be taken against the petitioner.
Heard Mr. H. Das, learned counsel for the petitioners. This application under section 482 of BNSS, 2023 has been preferred by the petitioner, namely 1. Ganesh Pathak and 2. Jonali Das, who are apprehending their arrest in connection with Gwalpara PS case number 87/2024 under section 120B/420/406/294/34 of the Indian Penal Code. The gist of accusation in this case is that on 7/6/2024, one Someshwari Das, who happens to be the maternal aunt of the petitioner number 2, had lodged an FIR before the officer in charge of Gwalpara police station, inter alia, alleging that taking advantage of the acquaintance with the first informant, the present petitioner took a loan of rupees 2,50,000 from the informant. And thereafter, the informant proposed to sell her plot of land to one Kiran Nath at the rate of rupees 15 lakhs. However, on the day of the sale, the purchaser, who wanted to deposit the consideration amount in the account of the informant, was asked to deposit the same in the account of the niece of the informant, namely the present petitioner number 2.
Petitioner number 1.
Petitioner number 1. It is also alleged in the FIR that thereafter she has been subjected to harassment, and the loan amount which was taken by the present petitioner, as well as the consideration amount of the land sold by the informant has not yet been returned to the informant. Stop. Learned counsel for the petitioner has submitted that the petitioner had approached on an earlier occasion also before this court by filing an anticipatory bail, which was registered as AB case number 1636/24. And as at that time, no FIR was registered,
Yes.
this court disposed of the said anticipatory bail application by order dated 26/6/24.
In that case, record was only just some report was called.
Ultimately, what happened to that case?
This case is pending. It will fix on 26. On that day, my lord, I will, my lord, close with liberty. I have mentioned here, my lord. The in paragraph, my lord, I have
You have
mentioned.
mentioned in this case.
Yes, I have stated in paragraph 18.
But in that case itself, you could have prayed for relief.
My prayer is that, my lord, anticipated and under one bail anticipated bail was filed before the honorable court for earlier non-registered FIR AB number so and so, wherein interim order was passed on 26/6/24 in favor of your petitioner, and records has been called for by fixing 26/7 for report.
Discussed
However,
of
after
what
registration
was
of
the
the
last-
FIR in PS case number so and so under section so and so,
Dispose of none.
not
As no FIR was registered, this court called for a police report fixing 26/7/24
24.
and an interim protection, an interim direction was issued that no coercive action shall be taken against the aforesaid, against the present petitioners in connection with FIR dated 7/6/2024. Stop. Learned additional public prosecutor submits that perusal of the case diary would be necessary. Hence call for the case diary.
26, I will withdraw the case. I have given undertaking. Your petitioner undertakes to withdraw the earlier baby number so and so now or not before so and so date. Fix except the said AB. There is no any other bail application file pending before the Senate.
Stop.
Paragraph 18.
Learned counsel for the petitioner has submitted that since the earlier anticipatory bail application has been was filed when no case was registered against him, he intends to withdraw the said bail application on 26/7/2024 when the said bail application is fixed for hearing. And to that effect, he has given an undertaking in the instant in his bail application. Stop. In view of above, in the meanwhile, the above named petitioner is directed to appear before the investigating officer of Goalpara PS case number 87/2024 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with Goalpara PS case number 87/2024, the above named petitioners shall be allowed to go on interim bail of rupees 30,000 each with one surety of like amount subject to the satisfaction of the arresting authority with following conditions. Number 1 and number 2. Let this case be listed again on
20 August, 28th.
20 August.
28th.
Abolishment. I leave.
Met please, your lordship. Yeah, my lord, the petitioner, my lord, with the husband, my lord, file a petition under section 13 of Hindu Marriage Act for seeking a, my lord, decree of divorce, my lord. In the said proceeding, my lord, the respondent wife has contested and filed her written statement, my lord, and during the proceeding of the said case, my lord, the respondent wife has, my lord, they are the decree holders in the shoot land. Thereafter, my lord, after filing of execution petition during the course of proceeding,
This is
On
item
one-
number
11,
11.
admission item,
Who is appearing for the respondent?
Mr. B. Sharma.
He
They
is
have
not
also
there.
filed their written objection also in this case.
What do we do today?
Your lordship thing, right, my lord. And because it is a matter of execution phase. And they are the decree which is not even challenged before any appellate court by the opposite side.
What you are challenging?
I am challenging the impugned order which your lordship.
No, but
filed.
respondent was appearing throughout.
That's Mr. B. Sharma.
We'll take it after some time or after some time. Let us see whether he appears or not.
Can it be a two?
Okay, at 2.
If they do not attend, then lordship will proceed.
Okay. What is this? Yes.
439 application lordship.
What is the offense?
Offense lordship recovery of ganja lordship.
How much?
23.46.
Commercial
43.
quantity.
It's a commercial quantity. We raise a point regarding this lordship that it is with the packets. So that is why lordship wanted to see the case diary. If
Is
it
there
is,
is there?
City receipt, lordship.
if it is excluded the amount of this, then lordship 12 numbers of packet was there. That is why if it is excluded, then I think it would be 20 kg. And if it is so, then in that case, lordship, it will be in intermediate quantity.
No, how will we find out?
That is, it will be in the CD, I think, lordship. It's
What is the weight of the contraband?
Weight of the contraband is 23.518 kg, lordship.
No, there,
5-1,
there-
not 5-1, lordship, as per FIR 23.436.
see the inventory,
Yes, lordship.
And then lordship, one
Hey.
more,
excluding the bag in which it was.
Yes, yes.
What is the weight of the actual weight of the contraband?
Lordship, this is 23.518 is with packet.
With packets.
With
Now,
packet.
packets have to be excluded.
Yes, lordship.
Now, what is the weight of the packets? Now, whether packets are such that it would weigh 3 kgs,
probably lordship.
what kind of,
Because it's 12 numbers of the, if we consider that 12 numbers of packets. If it would have one packet, then we could not raise that one.
no, if packets are not separately weighed,
Yeah.
then what will be the situation?
Then it, if we excluded that this 3 is 3 point something lordship,
No, no, why will you exclude 3 points? Here assuming, let him see, but assuming that packets are not separately weighed, and the contraband is weighed with packets, then how will we proceed? Then what is your submission?
To that regard, there is some, on last occasion, I argue on that point, Lordship, and one more point is there. Before answering that, kindly turn to page number 23.
Yes.
Page number 23 at note X, column 8, and then paragraph number 3. The women have been done at the PO, which is not in accordance with 52A, Lordship. In presence of witness and sample in packet have been drawn at the.
Weight may be done in the place of occurrence.
And then second line.
Sampling may not be done.
Lordship, sample in duplicate have been drawn at the PO.
Yes, that is not, but whether in presence of magistrate sample was drawn.
I don't think so, Lordship.
Lordship, there is a certificate by the magistrate under section 3 of the section 52
But Lordship, if
regarding
it
the
is-
correctness, and the certificate, it is stated, Lordship. This
But-
part only from the Caesar to that part only.
Lordship,
Lordship.
if it is done in the
All the
PO,
photographs.
then second exercise, they cannot be done. If it is done in the, and.
Yes, Mr. Bosho, you have to answer that. No. Later on, give this
No.
case.
Lordship.
Their submission is that sample was drawn at the place of Caesar itself. Then if something has been already extracted from the contraband,
Hmm.
then what was produced before the magistrate? And whether at the time of weighing before the magistrate, that sample which was already extracted was included or not?
No, Lordship. It is clearly stated that certify the correctness of the enclosed inventory, the enclosed photographs taken, and the list of samples drawn in my presence. It is 2/3/2024. It is judicial magistrate, Lordship.
Okay, so what is your response to
Response is that, Lordship.
para 23,
Pardon?
page
Yes,
23?
paragraph number 3.
13 to-
So sampling has been done twice.
Page 23. Page 20. Page 23.
Please. Mhm.
No, you show me that under such circumstances, you will get benefit if we don't know what is the weight of the packets.
Mala, two contention is there. Lordship, in one, the packets are not separated from the original contraband. Then thereafter, this procedure is not followed. In that case, Lordship, if it is so, in that case, Lordship, the Delhi High Court decided to that regard, Lordship. It is mandatory to wait, excluding the all the things, Lordship, wherever it was kept. So in that case, Lordship, if it is not done, that is one of the benefit in the trial. Then if samples not drawn before the magistrate,
No,
list of the sample also not prepared before the it is prepared at the spot, it is placed before the magistrate sign and certified that. That is the case. If it is the Lordship,
No,
then
but magistrate has given an endorsement that it was drawn in my presence.
it one of them. Then the two contentions is there, Lordship. If that is correct, then this will be false. This is the Caesar list. How can they make it false, Lordship? If this procedure is not followed and this is false, then entire thing is false, Lordship. All allegation is false. Then for that, Lordship, if we'll get the benefit at the end of the trial, why should we behind the bar, Lordship? This is the main crux of the case. It's a seizure list and it is seen by the magistrate.
But 52A is also followed.
But 52, if followed, then this seizure list is false, Lordship. Then that
No,
means
then
no,
you
no,
sh-
no
you-
seizure was made, Lordship, at that point of time.
No, you show me,
This is the base of the case, Lordship. Seizure is the base of the subsequent compliance is the 52. This is the base.
no,
First,
but your submission is for bail that 52A has not been followed. There is,
There two thing is there are two contention, Lordship. Three contention. One is that is not excluded, and one is Lordship. Second is Lordship. As per seizure list, investigating officer has seizing officer has seized the entire samples and all the things at the spot, and thereafter he produced before the magistrate. Magistrate certified that, but that is not mentioned in the seizure list. If base of the case is seizure list, on the spot seizure has been made. That is written by the official also. That is placed before the magistrate. Magistrate seen it. Both the thing cannot be done at the same time, Lordship.
why?
Because Lordship, if we believe the seizure list, then we cannot believe that thing.
No, why? I don't understand.
My lord,
I am
because,
giving you a situation, what happened in this case.
Lordship, if
Say there was a seizure of 23 kgs of ganja at this spot. At this spot,
samples
the ganja was weighed
and
and
so
sample was drawn.
then that sample reopened before the magistrate, and again weight and samples must have to take as per section 52. So that is not done.
Yes. So therefore, there is a violation of 52A.
52A. If there is violation of 52A, your lordship is very much aware about this Mongilal, and on last occasion in division bench, I argue on that one, lordship. If, all the Muhammad Yusuf, all this latest judgment, lordship, it is stated that the whole procedure will be violated, lordship. If 52A is not properly followed, lordship. If they will get the benefit at the end of the trial, lordship, why not right now, lordship? Because they are the educated boy inside the jail, lordship. These are the trauma, lordship, and not from my house.
No, I am concerned with
The recovery and all these procedures.
no 37 embargo. 37 embargo will go only if there is a violation of 52A. If there is a violation of 52A, we can ignore 37.
There is a violation of 52A, lordship, because this was
That you have to convince me that
yes,
because you go through the note of the what has been stated in the inventory. It is sample is you read out, please.
Yes, sir, no.
What is required under 52A is drawing of sample in front of magistrate
Yes, lordship.
and certification of same by the
Yeah,
magistrate.
sample
That has been done in this case.
list of samples.
May I read, Lordship? Lordship, on that part, I allow the above application.
Listen to him.
I allow the above application under subsection 3 of section 52A of Narcotic Drugs and Psychotropic Substance Act 1985, and hereby certify the correctness of the enclosed inventory, the enclosed photographs taken, and the list of samples drawn in my presence. That is 2/3/2024. Judicial Magistrate.
I allow the application.
Yes,
Application.
and the list of samples drawn in my presence. The word
Then,
there is.
lordship, as per section 52A, and
Sir.
then if it is done, lordship, then this seizure list then they reopen the packets.
And Lordship, before that also, regarding the correctness of the inventory, another certificate is there. Whereas the above officer applied to me under section 2, section 52A of the Narcotic Drugs and Psychotropic Substance Act 1985 to certify the above inventory, and subsection 3 of section required, and magistrate to whom and political is made to allow the application as soon as may be. I, having been satisfied that the above inventory is as per further documents and the consignments of the says goods related to the case presents before me, certify the correctness of the above inventory.
But in the application and the certificate, it is not mentioned that these were open in presence of the magistrate and thereafter re-sampling the whole contraband lordship. That is the violation of 52A lordship. 52A in the Mohanlal also it is decided lordship. At the spot, if anything recovered, then that will not be considered lordship. As per section 52A, lordship, shall prepare an inventory of such narcotic drugs, psychotropic substances, controlled substances, or conveyances containing such detail relating to their description, quality, quantity, mode of packing, marks, numbers, or such other identifying particulars of the narcotic drugs, psychotropic substances, controlled substances, or conveyances, or the packing in which they are packed, country of origin, and other particulars as officer referred to in subsection 1 may consider the relevant to the identity of the narcotic drugs, psychotropic substances, controlled substances, or conveyances in any proceeding under this act, and make an application to any magistrate for the purpose of certifying correctness of the inventory so prepared, taking in presence of such magistrate photograph of drugs, substances, or conveyances, and certifying such photograph as true, allowing to draw representative sample of such drugs and substances in presence of such magistrate and certifying the correctness of any list of samples so drawn.
No, can you find out any similar precedents? Any judgment which has dealt with similar situation where sample was drawn earlier at the spot, thereafter again it was drawn before the magistrate, and therefore it was held. It is
Regarding
held
bail lordship.
regarding bail. This is one query. Second query is where the court is, where from the records, it appears that the contraband was not weighed separately from the packets, and there is nothing to find out the weight of the packet, whether a benefit may be granted to the accused in borderline cases. Here, it is not a borderline case. It exceeds 3 kgs.
3.5 kg.
So unless we are convinced that the weight of packets are 3 kg plus, you will not get benefit on that count. So here there are two other cases. Mr. Dotto is also.
This is the Parhar
Say-
case. That are
In the same case. Same case.
that are not Parhar. I argue and the subsequently this case.
But same argument, you have other arguments.
I make my argument later on because today I have gotten a judgment of our court, my lord, a division bench judgment regarding 52A, my lord. I am going through it, my lord. Lordship may fix it next week.
So you also go through, find out,
My lord. I think.
because
Yes,
if one of you get benefit,
yes,
all will get benefit.
Yes.
If one of the bail application is rejected, all will be rejected. You answer my query, and in the meanwhile, you also answer the query, the same query, where there is nothing, because the requirement is that contraband should be weighed separately.
And that is weighted separately, Lordship. That part is available.
It
The
is-
Lordship may, if all the because there are different numbers of packets, Lordship. So whenever the magistrate seen the report and he said the photograph regarding the correctness part, every photograph is there, this separately.
No, no. These are in seal packet, Lordship. Lordship can see.
No, no, I am saying about the weight.
No, no, no. I took
I'm not saying about the sampling.
That is, it is in seal packet,
Sampling part is
Lordship.
different. No? I'm saying about the weight. Lordship, may kindly see that part from this.
We cannot see the CD, but the packets are in packing mode.
From the scissor part to race part, Lordship, I have flag mark. From from that page onward.
No, these are, all these are with packets.
No, with packets, Lord. With packets.
So their submission is that packet also contains some weight.
Yes, Lordship. So because that is that weight is higher that my learned friend has submitted. Because as per the FIR, the weight is how much it is?
23.
23.436 kg. But along with the packet, Lordship, it is more than 23.5 something kgs. So that is the
How
difference,
it
Lord.
will differ,
Okay, we'll consider it. You come prepared with my queries, all three. Heard, Miss S.K. Nargis. Separate orders hobo, তিনি ওটাতে। In bail application number 1, same order will be there, but name of the council would be different. Also heard Mr. K. Bosho, London additional public prosecutor, who has produced the case diary of Hatigam PS case number 39/2024. During the course of the hearing, it was pointed out by learned counsel for the petitioner that the seizure list in this case shows that the contraband was weighed and sample was drawn at the place of occurrence itself in presence of witnesses, which according to learned counsel for the petitioner is clear violation of the mandate of section 52A of the NDPS Act 1985. Stop. Whereas learned additional public prosecutor submits that it is mentioned in the certificate issued by the concerned magistrate under section 52A that the sample was drawn in front of him, and thereafter the said magistrate has certified the correctness of this drawn sample. Under such circumstances, learned counsel for the petitioner has sought for some time to come up with some authorities in this regard. Learned additional public prosecutor also,
Lordship.
you also take,
Yes, yes, I will also just note something.
he also submits that some time may be granted to him so that he can answer the queries posed by this court. The prayer is allowed. Let this case be listed again on Monday,
29,
on 22nd,
22nd
CD
or
to be retained,
29.
Lordship. Till then,
29,
29/7.
7.
The case diary shall be retained till that day. Same order in all three cases.
Obliged.
CD খন ঘূৰাই দিওঁ। What is this?
Here, one problem I am facing. I file a suit, the appellant file a suit, and the defendant did not file any counter claim. And the performer defendant 1 to 4 has filed counter claim. The learned court below is, my lord, dismissed my suit and partly allowed a counterclaim. Against that, I filed an appeal, and they also filed an appeal.
They
Again,
means the pro forma defendant
former defendant. They filed an appeal.
against the part which was rejected, dismissed.
Then, my lord, my appeal was also dismissed. Their appeal also upheld and simply modified.
The
And-
decree was modified.
And thereafter, I filed two appeals here against dismissal of my suit and against the order judgment and decree passed in counterclaim. Two appeal. Now, what happened? Well, during pendency of this two appeal, the permanent defendant number for expired, and I filed a substitution petitions. Then, in item number 16, in Lordship kindly say, in that case, just substitution petition has allowed their appear, my friend appear, all the respondents, my friend appear. But in next case, my lord, what happened? I filed a substitution petition 130, but it is wrongly, my lord, withdrawn. It has been wrongly withdrawn by mistake,
By whom?
by the from our side, my lord. It is later we come to notice that it is wrongly withdrawn. Already in one case, all of them represented. Then that is why I filed a petition here in the second case for recalling that order. And since there is a delay, I also filed a petition for condemnation of delay. IN number.
Recalling
20
that order under what provision?
I filed this petition under 151. My lord, 2028.
Your substitution petition was withdrawn
Withdrawn, wrongly withdrawn, my lord.
in RSA 3650.
Actually, it's the filing number. It is filing number
Why it has not been yet?
because since there is a delay,
That limitation case is still pending.
it's still pending. On that, during that pending of this petition, the respondent was performance respondent one expired. Then
No,
I filed a petition.
no, I have not understood.
Lordship,
If one query before you answer.
see IN number.
No, before you answer, let me put a query. If your suit has, if your second appeal was not registered, how you can file substitution petition in that suit? Appeal?
Because while this notice was issued in condemnation petition, then I come to learn, my friend also informed that so and so has been expired.
But then substitution petition will come only if your RSA is registered.
Lordship, that is allowed. Lordship kindly say IN number 3600/2022. That IA.
36.
It would allow.
36.
So substitution, if substitution is allowed,
Allowed.
this petition will be infructuous.
No, substitution allows in two appeal, my lord. In one appeal, substitution already allowed.
3600.
0, it was filing number. And subsequently, RSN 115 has been registered.
No, why these two appeals are tagged together?
Because against the same judgment, we filed two appeals.
Okay.
Against the same judgment. And my friend also filed
So
appeal.
in RSA 115, there is no issue.
No issue. And then no issue already, all are substituted
It is come up for this
for additional
substantial
law.
question of law.
Subsequent question law.
Others are take. The second one is also Lordship.
Same, my lord. Same respondent, same appellant, same respondent. So 130 I
Others, the other second appeal, unless the condonation of delay application is allowed,
yes.
it cannot come up under order 41 rule 11.
Now, 115 has been come.
Those two cases are taken with the item number 16. Item number 18 already substantial question of law frame so far as my appeal is concerned. 18. And in item number 17, Lordship, delay condonation petition, Lordship, the service is not complete. What the office note says. So only this 16, it is come up for
Under order for
substantial question of law.
for admission.
In item number 17, if your lordship sees that office note dated 21/5/24. In item number 17, IA
Yes.
231519.
Sudeep Agarwal.
231519.
No, item number
17.
17, that is,
2315/19 is a delay condonation petition and that is going on.
no,
right
just
now.
a minute. RSA 115.
It is 16 item.
16. Then
Item
RSA
7.
3560. Sudeep,
It is the
365.
filing number.
That is the filing number.
Filing.
Lordship kindly say
Item
IA
number 17.
2315. 2315 delay condonation petition.
Delay condition. And put it.
Their lordship kindly see the office note in IA. 21/5/24.
Respondent number 2367 not yet served.
That is,
You are not appearing for them.
no, I'm appearing for respondent number 1/4
This I is for
delay condonation.
condonation of delay.
During pendency of the petition, former defendant expires.
And
That is
already
why you will file.
substitution are made, lordship. I think cost title is corrected in that IA itself. You are not, lordship kindly see the cost title. If it is correct,
Substitution in I application.
done, it is, I think. Lordship.
Yes, it was done.
Yes, so these two miscases they have filed, those will be infractions
Which two?
2028, 2029.
29.
2028 and 2029 are for?
Infractions are.
So let us go one by one. In delay condonation against item number 617, we will wait for service. What should we do? You will take fresh steps.
No, my lord, my friend already
No,
applied.
no.
He is not appearing
I
for,
am appearing for one, respondent number 1/4 and 51258.
he is not appearing for 2, 3 and
No, I'm not.
6 and 7.
2, 3 are not expired. They are 2, 3
No, but
and others are definition. The other two.
No, more call it. 1, 4, 5.
I don't think so. Not current.
Yeah, 145.
1 to 5.
145.
So I just took them.
yes, Mr. Ahmed,
My lord.
make your submission. What?
Yes.
Either you take fresh steps in delay condonation
Delay condonation.
application. Or 2, 3, 6. Who are 2, 3, 6 and 7?
They are former defendant. They are
The legal heirs of respondent number 5
Madai Sarkar.
were allowed to be substituted in which IA? 3600. Okay, in IA number 2315, right? Heard Mr. J. Ahmed, learned counsel for the applicant. Also heard Mr. J. Deka, learned counsel appearing for respondent number
1/4 51258.
14
5 bracket 1 to 5 bracket.
5 2 TO2 5 within bracket 8. It appears from office note dated 21/5/2024 that the notices sent to respondent number 2, 3, 6 and 7 have not yet returned. The applicant is directed to take fresh steps for issuance of notice on the aforesaid respondents by registered post with AD as well as by usual mode. Within
Respondent number
respondent number
2 and 3.
respondent number 2, 3, 6, and 7.
2, 3, 6, 7.
Who is for 8? You are not appearing
No.
for it. 2, 3, 6, 7, and 8. Eight. Within a week from date of this order, returnable after 4 weeks. List this case accordingly after 4 weeks.
The order is passed in item number 17.
No, this order is passed in item number 17, 2315, IA number 2315. Now there are 2 more IAs. Which
Then
This one is in infrastructure, no?
that those petition, like I may be allowed to. That is remain. Later I will I will withdraw it.
no, if it has become infructuous, we are
Yes.
disposing it of. We can dispose it of today itself. Heard Mr. J. Ahmed, learned counsel for the applicant in IA number 3600 was allowed. It is already disposed of. IA number 2028. Where is 2028? Heard Mr. J. Ahmed, learned counsel for the applicant. This application. No, this is for recalling. And this is for recalling the order.
Order passed in I number 130/2000. It will be some of the time.
What order was passed in 130?
It was police order dated. It is make a submission that that petition is to be withdrawn.
Lordship 130 was for the substitution.
That was substitution.
Then they have
But-
filed another IA for correction. When filing the correction that 3600, then that is not this earlier one. Ultimately, substitution is done. So there is no point now. So far as this
If
two
substitution
IA is
done, my lord,
concerned.
Then this recalling of order is not necessary.
Not necessary now.
Learned, heard Mr. J. Ahmed, learned counsel for the applicant, who submits that in view of the order passed in IA number 3600/2022, whereby the substitution of legal heirs of respondent number 5 was allowed. This petition has become infructuous and therefore the applicant does not intend to press the same. In view of submissions made by learned counsel for the applicant, this IA is dismissed on becoming infructuous. This is IA number 2029. 2029. What remains?
2028.
2028. 2028 deo.
to do it for condemnations. It was
Control. 2029. 2028 is also for recalling.
2028.
Same order, same order.
Same order.
Same order. 2028 to 2029. Now these applications are to be heard together.
That is not, Lordship, because if Lordship finds that there is no substantial question of law to be framed, then your Honor, Lordship will not.
Then I take a step, my lord. Then all the matter, since his appeal already been admitted, earlier this owner could fix the matter along with those matter to see the appeal. So, on that day, those both the appeal will be heard.
No, your matter has been
Only-
admitted.
Already been admitted.
Then why it
substan-
has come under,
Because
for
on
hearing-
last occasion, all this
Case was fixed.
case was taken,
Take,
but it is
we-
not necessary to take Lordship. Because all
On
are,
16
all are individual cases.
Item number 16 order was passed. The all cases to be
but the records of the trial court would be only one record.
one records.
That pertains to item number 18. Because substantial question of law was framed, LCR is called for. So
No,
that is pertain to
Only
that.
one record.
18.
This,
Now assuming that in item number 16 and 17 also, if
yes.
substantial question of law is framed, if
Then-
it is,
Then
Same
at this
record.
stage of hearing,
then it may be tagged.
that, but not, it is not the stage, because other two matters may come up for orders.
Understood. Yes.
But that was
When
fixed
the
because
substantial
the
question
owner,
of-
while that matter was heard. the
No,
owner-
otherwise we are getting difficulty in going
Yes,
through the
it is
records.
Confusing.
If so many records are tagged together,
Right.
it becomes difficult to go through the records.
17 and 18 may be listed in the order,
Orders column,
and this may be
16
listed
and
for.
16 and 17.
no, 16 and 17 in orders column,
Orders.
and 18 will be admitted, is already admitted.
Admitted
It
to
will
hearing.
go for hearing,
Yes.
Yes,
18.
LCR is called for, so that will go for hearing.
I say
LCR is,
received. Yes, received, sir. So, our number is one and the not discussion.
LCR I say nahi.
So, thank you.
LCR is there, Lordship.
Office notice, yes. Heard Mr. This is item number 18, huh?
Item it.
18. Heard Mr. J. Deka, learned counsel for the appellant. Also heard Mr. J. Ahmed, learned counsel for the respondent. Respondents. The trial court records which was called for has already been received by the registry. Let the same be tagged with this case, this appeal. Learned, it is submitted at bar that this case is ready for hearing. And therefore, this case may be fixed for hearing and it may be detached from item number 16 and 17. The prayer is allowed. Let this case be listed for hearing on a date to be fixed by registry. And let this case be detached from the case record of RSA 3650/2019 and RSA 115/2023.
In this case, my name may be shown in the court list.
Yes. The name of the counsel for the respondent, Mr. J. Ahmed. No, the registry is directed to show the name of the counsel for the respondent, Mr. J. Ahmed, in the cause list henceforth.
Lordship, that RSA 3650, it is a filing number.
Filing number it is.
Oh, yes.
Otherwise, it will be a confusion.
3650 within bracket filing number.
Filing. Item 17 may be listed for orders, Lordship, since service is incomplete.
In item number 16,
16 and 17.
16 and 17, common order. Common order. No, we have passed separate orders in IS. In item number 16, in item number 16, heard Mr. J. Ahmed, learned counsel for the appellant. Also heard Mr. J. Deka, learned counsel for the respondent.
Respondent 1451258. Not all the respondents. In item number 16.
Mr. J. Deka, appearing for respondent number
1451258.
one and respondent number 1, 4, 5 within bracket 1 to 5 within bracket 8. Let this matter be listed along with RSA 3650/2019 within bracket filing number in orders column after 4 weeks.
Obliged.
Nikita Loiza.
May it please your lordship, I am here. This is second appeal against concurrence finding, my lord. I am the plaintiff appellant, my lord. Plaintiff's suit is for declaration of right, title, interest, and cast possession over the suit land and cancellation of sale deed of the defendant exhibit as forced to annul. What's plaintiff's case, a land measuring 3 big of Kepi Patta number 90 of comprising of 4 ducks, my lord, and it was inherited property of the plaintiff from her mother. The plaintiff's mother purchased the same.
I'm not getting anything. You are not audible. Yes. Repeat what you have said.
This is second appeal against concurrent finding, my lord. I am the plaintiff appellant. The plaintiff suit is declaration of plaintiff's right, title, interest, and cast possession over the suit land and cancellation of sale deed exhibit co.
Okay. You filed a suit for cancellation of sale deed.
Yeah, that, declaration of right, title, and confirmation of cash possession, my lord.
Okay. Declaration of right, title, interest, and confirmation of cash possession. Thereafter, what happened?
My land measurement of the suit land is 3 bigger and it is in comprising in 4 ducks, my lord, 344, 393, 397, and 387. And it was the inherited property of the plaintiff. The plaintiff inherited the property from her mother. The plaintiff's mother purchased the suit land by registered sale deed number 1097 of 81. Thereafter, the plaintiff in need of money kept the suit property in mortgage for 6 years to the defendant's from 2003 to 2008. After the expiry of the mortgage period, the plaintiff is now enjoying the possession of the suit land. Then the defendant demanded
You mortgage the suit property to
the defendant.
the defendant.
For
Thereafter,
after the expiry of the mortgage period, the plaintiff is now in possession of the suit land. But the defendant demanded that they purchase the suit land on 2004 by registered sale deed number 67 of 2004, my lord. My contention is that I have never executed the sale deed. Moreover, in the sale deed, the plaintiff's husband name and address are not properly correctly stated, and my specific case is my land is in 4 ducks. but in the sale deed, there are only mention of 3 ducts. 3 ducts in there. And the trial court finding is at page number 30.
Trial court dismissed your suit.
Dismissed, then I.
On what ground?
That the trial court interpreted the document in the favor of the defendant, my lord. Exhibit 4.
Okay, thereafter,
Thereafter filed appeal, that was also dismissed.
on what ground?
Same ground, my lord.
What ground?
That if your lordship may kindly come to the page number 30. May I read?
Is what substantial question of laws is in here?
Number 1, 2, and 3, my lord. They constitute the exhibit in favor of the defendant, contrary to where my specific case is that in exhibit 3, which is my sale deed, the land is under the land which I have purchased in 4 ducts.
Now let us go through the first substantial question of law which you have framed.
Your lordship may come to page number 30, my lord, where the I could have come to a finding.
Page number 30.
30.
Yes,
In paragraph 5.
yes.
PW1 and PW2 depose the sale deed forged as in sale deed number 67/04. The name of plaintiff's husband is not correct and the doc number 397 is not mentioned. It is to be stated that in sale deed, the name of plaintiff's husband is given as Mulong Shen, but Mulong Shen is the father of the plaintiff. The entry of plaintiff's name in Jamavanti is daughter of Mulong Shen.
Yes, read.
And the defendant is claiming that draft of sale permission and sale deed is prepared by one Savin Kachari, and it is due to oversight of the scribe writer that mistakenly he has written Mulong Sheikh as husband of plaintiff, and defendant could came to know of such mistake only in the year 2009. It is pertinent to mention that plaintiff and defendant known to each other from earlier. The defendant was Pattada in the suit, but even before purchasing suit land, as the defendant has his own land adjacent to the western boundary of the suit land. Hence, obviously, plaintiff and defendant were well known to each other. It is also not the defendant who purchased the suit land giving some other name not relating to plaintiff. Defendant name clearly stated that he
What sale did the defendants are showing before the,
Exhibit 4.
who is the seller?
The defendant demanded that I have sold the land to the defendant.
You are the seller. And okay. Now, let us go through the substantial question of law which you are. Read out the first substantial question of law.
Whether the courts will writing law in constituting exhibit court sale deed number 67 at 0.
Oh, where is the? You have mentioned in page 3 of
No, I have given a separate sheet today.
separate sheets, whether it can be given
It can be given
under what law?
generally.
Generally will not do. You read section 100. Section 100 says that your memo of appeal should precisely state the substantial question of law. It's because your memo of appeal says something different.
No, I have requested the.
Then you have to amend your memo of appeal. If you want to change, because it is your,
Generally, we
no, generally will not do. You will rely on some law. Either some procedure has to say. I don't know what is. What section 100 says.
at the time of admission of the appeal, we give the substantial.
Under what provision? If there is some rule, I will allow it. You take time.
Yeah.
We'll take it up after lunch. If you can show that the substantial question of law need not to be there in the, then I'll allow it. You may take time. The substantial question of law cannot be given like draft issues. That is my understanding. You have to make me understand. After, yes.
Lordship, in item 19, Lordship, 20, Lordship, there is also a mistake, Lordship, at the time of drafting the memo of appeal, Lordship. Some other substantial question of law were included in the memo of appeal. So I am also with a sheet of substantial
Yes.
question. So I may be allowed to file amended cost title by tomorrow. Your Lordship may fix it on Friday, Lordship, item 20.
Okay. You may amend your memo of appeal.
Lordship.
There is no bar.
Lordship, kindly record that by amending the cost title, Lordship, by press substantial question of law. As my memo of appeal contains the substantial question of law, some other RSA, Lordship. It is my mistake at the time
Then
of
you have to
title,
amend that.
Lordship. For that amended cost title, I will submit, Lordship, by tomorrow.
Month of August, I'm for the respondent number.
You have appeared.
I appear, I'm the caveator.
Okay, okay.
Lordship, there is also something, can we fix it on Friday?
After lunch, I will come.
Lordship,
After lunch, because I have to go through the records also.
Lordship,
Before allowing your prayer,
Lordship.
we have to go through the records.
Lordship.
So after lunch, we'll take up both the. Yes, what is your prayer?
Maybe allowed to amend the
Memo of appeal.
memo of appeal and your lordship can fix it on day after tomorrow on Friday.
Okay. Miss
That's right.
S. Roy, learned counsel for the appellant who prays for allowing the appellant to amend the memo of appeal as some alterations are required in the substantial question of law framed by the appellant in the memo of appeal. The prayer is allowed. Let this case be listed on 26. Well, in the meanwhile, the appellant may submit the amended cost title as well as amended memo of appeal. List this appeal accordingly.
With your lordship. In this case, lordship, while preparation of the appeal memo, lordship, page 5, your lordship will find. Due to typographical mistake, lordship, the earlier substantial question of law of some other RSA is incorporated in this case, lordship.
Okay,
So I am also having a separate sheet, your lordship. So if your lordship kindly allow me to, lordship, file the amended cost title and take this matter to day after tomorrow, lordship.
heard Miss R. Chaudhary, learned counsel for the appellant, who submits that due to inadvertence, the substantial question of law of some other case has been incorporated in the memo of appeal of the instant appeal. And she prays for allowing the appellant to file an amended memo of appeal
By tomorrow, lordship.
by tomorrow. The prayer is allowed. Let this case be listed again on
Friday, lordship.
Next week, because I have to read the question of they will.
No, that
punish
I
me.
have already given to him, lordship, earlier official
What?
lordship.
My learned friend will file with the court, I have to see one, time, some time next
Similar
week.
substantial
next
question of
week,
law. I will
lordship.
file.
execution is pending.
No, there is no exam case filed.
Okay, then let it be next week.
Lordship.
On when?
Any date?
On a date to be fixed by registry. Let this case be listed in the next week on a date to be fixed by registry.
Or lordship, liberty may be given to me, lordship, to mention this matter for listing.
Yes,
After
no,
filing.
liberty not, you can mention at any time.
Lordship.
In the meanwhile, the appellant may file the amended memo of appeal before the next day, list accordingly.
Obliged.
Obliged.
May please, Your Lordship. Your Lordship, this second appeal arises out of dismissal of my appeal. Your Lordship, filed before the learned civil judge, Senior Division, Barpeta, by the order dated 16/5/2024, Your Lordship. The fact of the case, Your Lordship, herein, Your Lordships, the plaintiff has filed a suit for declaration, recovery of position, and permanent injunctions. And the defendants, that is the appellant before this, Your Lordship, file a WS along with contact claim for declarations, confirmation position, permanent injunctions. So trial courts, after hearing Your Lordship, trial was pleased to degree the suit and dismiss my contact claim, against which I file my appeal before the civil judge, Your Lordship. And that also got.
You are in possession of the suit land.
Yes, I am in possession of it.
Your counterclaim was for confirmation of possession.
Confirmation position, permanent injunction, Your Lordship.
Okay. Then what happened in titles?
So ultimately, my appeal was also dismissed, Your Lordship. And against which I am before Your Lordship. The fact of this case is, Your Lordship, the plaintiff is at page 22, Your Lordship. Most particularly page 23, Your Lordship. Para 2, Your Lordship. The suit land is the on-land property of the plaintiff having his own right, title, interest, and position over the same. Plaintiff acquired the suit land by clearing forest and his own effort, and he was possessed the said plot of land since the day of taking possession and cultivating thereon. Thereafter, in connection with the order of the circle officer dated 2/7/2011 regarding the petition filed by the petitioner by petition number so and so, the plaintiff got the said plot of land transferred into the periodic patta lands by patta number 235 in his own names by paying premium to the governments, and accordingly said report was recorded in the revenue record 23/8/23. Next, Your Lordship, their contention is that the plaintiff also have a land property other. He says that the defendant disposes him from this land, Your Lordship. This is his case. I have dispossessed him from this land, and thereafter I have given some land for the mosque and muktab, Your Lordship. My case here in Your Lordship is that his father, in fact, Your Lordship, his statement that he purchased the land your lordships, he cleared the forest and all is not correct, your lordships. In fact, there is a annual patta lands standing in the name of his father. And his father sold the land out of 4 bigger 1 kata, your lordship,
Whose father?
the father of the plaintiff. Father of the plaintiff sold the land to me, your lordship, out of your lordship 4 bigha. Your lordship, out of 4 bigha, 4 bigha 1 kata 8 lesa. His father sold me the land within 3 kata 3 bigha 3 kata 8 lesa by Kecha sale deed, your lordship.
What sale deed?
Kecha sale deed, unregistered sale deed, your lordship.
What is unregistered sale deed?
A sale deed without registration, your lordship. Possessory that was delivered because that property was sold at the time of annual patta land. And in the annual patta land, your lordship, the title always remain with the government. So that was the only transfer of possession, your lordship. So ultimately the possession was transferred through Kecha sale deed, your lordship. And the learned trial court, after going through the evidence, he dismissed my plan, saying that this unregistered sale deed is not registered, and he disclaimed your lordship, my claim. In the meantime, what when your lordship, during pendency of
You purchased possession of 3 kathas.
3 bigha 3 kata 8 lesa.
Now out of 4 bigha 1
4
katha,
bigha 1 kata 8 lesa.
how much you have purchased?
3 bigha 3 kata 8 lesa. Only 3 kata land remain in the name of their father.
Okay.
Father of the plaintiff.
Okay.
As per my contention, your lordship.
By unregistered sale deed.
By unregistered sale deed. So, your honor, my contention here is that I purchased that land. At the time, it was annual patta lands. And after that purchase, I am in possession of the lands. How thereafter it was settled in his name, periodic patta was issued in the name of the plaintiff. Because a periodic patta.
What is the substantial question?
Your lord.
No.
Before that, your lordship.
Before, why the?
Before that, one fact I want to bring your lordship.
Yes.
During the trial, your lordship. During the trial, your lordship.
Just a minute. The trial court dismissed your suit
my contact claim.
on your counterclaim on the ground that you do not have any.
My right, your lordship.
Because of want of registered
sale deed.
Okay.
Now, your lordship.
Okay.
Your lordship.
And why their suit was decreed on what basis?
On the basis that they have a your lordship annual patta land in the name of their fathers, and it is converted into patta lands in his names, and there is an allegation that I dispossessed him. So the finding of the court that the title is standing in the name of the plaintiffs, and I dispossessed him. This is the case, finding, your lordship.
Okay.
Other finding I come to your lordship. Before that, I want to come one thing, your lordship. Here, what happened, your lordship, during the pendency of the suit, 2 of the main defendants expired.
Okay.
And I have given your lordship. So, in fact, your suit awaited at the time of trial. It ought not to have been decided, your lordship. Death certificate, your lordship, as paid, one death certificate is by 91. Page 91.
What is this?
Your lordship, page 91. Sohrab Ali.
How many defendants were there?
Defendants, your lordship. Yes. Your lordship, 6, 7 defendants.
Where is the plaint? Copy of
Plaint is
plaint?
at page 27, your lordship. Most, your lordship, tab copy, page 22.
After these defendants who expired, Sattar Khan.
Sattar Khan and Sohrab Ali.
Okay.
And these 2 expired, your lordship. One expired on 6/2/16 during pendency, and another expired, your lordship, on 28/9/17. The judgment of the trial court was of your lordship you know, 30 April 2021. This now. 30 April 2021. So these both defendant expired during pendency of the suit. And they are the main defendants. So ultimately, your lordship, the suit was abated. On demise of these two persons. your
No,
lordship.
who are you?
I am the defendant number 7, your lordship.
I'm sorry. Allegation of trespass and dispossession was against all these,
All this, your lordship.
all the defendants.
Your lordship. So
Okay.
they made the party, they are the main defendants, your lordship. We are,
All are main defendants.
all are main defendants, your lordship. So your lordship,
The
in the,
question of main, word main will not come. All are
it is
defendants.
all the defendants, your lordship, principal defendants.
Yes.
So it is a.
As
principal-
there is no pro forma defendant, the question of main principle, these
it also does
adjectives
not
are
deny,
not
your lordship.
necessary.
It is a defendant, your lordship.
Okay.
In fact, they use the word main defendant, so I said, your lordship. In fact, the main defendant, your lordship.
Okay.
Two of the main, the defendant expired, your lordship, and this ground I have taken in the memo. Page 108, your lordship.
Now, what is the substantial question of?
So substantial question of law, your lordship. Here, one of the substantial question of law, your lordship, substantial question of law, your lordship find at page 21, your lordship, of memo lordship. First is whether the suit of the respondent plaintiff is abated on demise of the respondent, defendant number
This
6.
is a question of fact, whether it abated or not.
Your lordship, thereafter, your lordship, thereafter. Defendant number 6, Saurabh Ali on 26 and a death of the Sattar Khan, who died on 28/9/27, and degree passed by the London trial court in TS number so and so, that is so and so, and applied for so and so against the dead person is a nullity.
Okay.
A degree is nullity is a question of law, your lordship.
Against them, it may be nullity.
Yes, it is your lordship. One thing, your lordship.
Against both of them.
Your lordship, here there is no divisibility of the schedule. Here is the narration of the plan.
Okay, okay.
So it is a one schedule, your lordship. So who is sitting where? How can it will be a certain, your lordship?
Okay.
So this is one substantial question of law, your lordship. Second, your lordship, whether the conversion of annual patta land to the periodic patta land without possession is as per law. Third, your lordships, there your in the plan they says that by order of the circle officer, the annual patta land converted into patta land. Whether
No,
the
it substantial question on number 1 and 4, 5.
5, your lordship, 5 and 6, your lordship.
Heard Mr. N. Jha, learned counsel for the appellant. This appeal under section 100 of the Code of Civil Procedure, read with section 151 of the said code, has been filed by the appellant Samsul Haq, impugning the judgment and decree passed on 6/5/2024 entitled appeal number 3/2022 by learned Civil Judge Senior Division Borpeta. After hearing learned counsel for the appellant and after perusing the memo of appeal as well as the documents annexed therewith, following substantial question of law is formulated in this second appeal. Number one, whether the suit of the plaintiff suit of whether whether on whether during the pendency of the title suit number 338/2012, on death of defendant number 6, so Surhab Ali, on 26/2/2016, and on death of defendant number Sattar Ali is defendant number
3, Your Lordship.
defendant number 3, Sattar Ali, on 28/9/2017. The decree passed by the trial court in title suit number 338/2012, as well as in the decree passed in appeal decree passed in title appeal number 3/2022 is a nullity or not, as it was against dead person. Number two, whether the sale deed transferring possessory right of annual patta land is compulsorily registrable or not. Number three, whether entry made in the Sitha or draft Sitha as per section 40 of the Assam Land and Revenue Regulation 1886 is a conclusive proof of possession of a person in whose name is appearing there or not, question mark. Issue notice to the respondents. The petitioner, the appellant shall take steps for issuance of notice to the respondents by usual mode as well as by registered post with ID within 3 days from the date of this order, returnable after 4 weeks, list according.
Your Lordship, IA is also there.
Is there any execution case filed?
Yes, it is pending, Your Lordship.
Suit land is in your possession.
My position, Your Lordship. Admittedly, Your Lordship.
What is the execution case?
It's necessary.
Execution case number?
Lordship, sorry, I have not mentioned this, Your Lordship, but it is pending.
Why should I believe you?
Your Lordship, it is pending. I am saying on a spot, Your Lordship. As my appeal is admitted for hearing, Your Lordship, the judgment
No,
may be
but
stayed.
But you're, without hearing the other side,
Your Lordship,
if there is a imminent,
Your Lordship, as the execution petition already filed, already filed, Your Lordship.
no, you are coming in second appeal.
Yes, Lordship.
So you have to come prepared.
Yes,
You
Lordship.
are threatened by execution and
Yes,
you don't
yes.
know the execution number.
Your
Therefore,
Lordship, Your Lordship, my humble submission here.
I'm issuing notice.
No, Your Lordship, as till next date, it may be issued, Your Lordship, I will come up on that day. It may be a stay till next day. I will come up with that.
What I will stay?
Your Lordship, execution of the judgment and decree, Your Lordship.
In which case?
In title suit, Your Lordship.
No, in a title execution case.
And in title suit, the appeal, judgment degree pass in the title suit, Lordship.
But for that, an execution case has to be filed.
It is there, Your Lordship. It is there.
Okay. This have heard Mr. N. Jha, Learned. You should have come prepared.
Your Lordship, I'm sorry, Your Lordship, I would have.
Heard Mr. N. Jha,
Huh?
Learned Counsel for the applicant. This application under Order 41, Rule 5, read
That
with
is
Section 151 of CPC, Code of Civil
21.
Procedure, has been filed by the applicant, who is the appellant in the connected regular second appeal number 125/2024, praying for stay of the execution of the decree passed in title appeal number 3, decree passed in title appeal number 3/2022, passed by Learned Civil Judge Senior Division, Barpeta. Learned counsel for the applicant has submitted that the decree holder has already initiated an execution proceeding by filing an execution case before the executing court. However, he does not have the case number of the said execution case, and which he,
Your Lordship, sorry, sorry. I have already mentioned in para 11. My petition.
what is the case number?
Case number, title execution number 84/21.
In line to continue. Execution of the decree in title execution case number 84/2021.
21, Your Lordship, 2021.
2021.
Para 11 of my state petition.
Okay. Issue notice to the opposite party, issue notice to the respondents. The applicant shall take step for issuance of notice by usual mode as well as by registered post with ID within 3 days from the date of this order, returnable after 4 weeks. In the meanwhile, as the regular second appeal number 125/2024 has already been however, in regular second appeal number so and so, already the substantial question of law has been formulated and notices have been issued to the respondent. Therefore, till the next returnable date, the execution of the decree, of the impugned decree in execution of the impugned decree shall remain stay. List accordingly.
Much obliged, Your Lordship.
Other side is not there. You are petitioner.
Yes, my lord. What happened in this case, my lord? We are the decree holders. In
You are
this
the
case.
decree holder.
Yes. So while filing, on being waiting for some period of time, as the said decree was not challenged by the respondents in any court of law, we have filed an execution petition against them. And during the course of proceeding, my lord, for 2 consecutive dates, no steps have been taken on the part of the decree holders in the executing court, and it was dismissed for default. Thereafter, my lord, we have filed a restoration petition before the same court. But
Execution case.
yes, my lord,
Okay.
that was not restored,
Execution case was not restored.
not restored. And on being agreed with that, we have filed this in the civil approach before the learned civil judge, but that was also declined. That's why we are before your lordship today. Actually, by imposing some costs, the learned court below executing court ought to have restored my case, because there is no appeal filed by the judgment debtors. And in the On the other side, all necessary steps for execution of the decree was completed accordingly.
No, whether execution case,
After, when it was pending, before transfer of the amalgamation of district, all necessary steps have been completed. But all the subsequent steps was initiated after transfer of the said shoot to the Baksa district in fresh. But accordingly, with regard to steps, procedural steps was completed. And necessary challans have been already been deposited before the concerned office for security personnel also. But due to amalgamation of new district with regard to jurisdiction, the matter was transferred to Baksa and it was initiated in fresh. So at this stage, if we have been ignored in such a manner, arbitrary manner, then it will cause lose our substantive rights.
why it was not, what first appellate court said?
First appellate court said that there is no provision because the matter was for to take steps, not for fixed for hearing. So far as the provisions of CPC. So
Where is the order?
operative portion of the order, your lordship will find from page 84 onwards.
Page?
84. A part of the IPUN order. Page 84 in paragraph.
No, whether the respondent have filed
No,
file
respondent
objection.
Respondent has not filed any objection there.
in this
On-
case,
In this case filed.
they have filed objection.
They have taken the defense on the by quoting the finding of the learned court below only. They have no
No, where is the impugn order?
impure order is page 84, the operative portion. What your lordship is notice. Discussion, decision and reason thereof.
Please read.
In paragraph 6, I have heard argument forwarded by the learned counsels for the appellant decree holders as well as the respondent or judgment debtors, learned counsel for the appellant decree holders, argued that the impugn order is erroneous and is liable to be interfered with in appeal. The learned counsel for the respondent judgment debtors argued that the order passed by the learned trial court is proper and sound and does not require any interference. Peruse the orders passed by the learned Munsi Rangia in title execution number so and so, which reads as follows. On 23/1/17, decree holder is duly represented. Decree holder is directed to take steps within 1 week, fixed 25/4/17 for return of original challan and necessary order. Next, it was fixed on 25 April 17. 25, what happened in 25/4/17? Decree holder is absent without any step, fixed another date 29/5/17 for NO. And next on 29/5/7, the impugn order is passed, which is under challenge. Decree holder is absent without any step. The instant title execution case stands dismissed for default on the part of the decree holder. That is the main subject matter of challenge.
Okay.
This is the, but there is no other, no
You
specific.
can read thereafter. What was
Thereafter, my lord, coming to paragraph 8. Against the said order dated 29/5/17 of dismissal of the execution case, the decree holder preferred a petition under order 21 rule 106 subsection 1 of CPC read with 151 CPC, which was numbered as 755/17 dated
You
21/6/17.
preferred an application under order 21.
Order not 21 rule 106 subsection 1 of CPC read with 151 CPC.
Order 21 rule 106.
Yes.
What is it?
For restoration of title execution case number 0516, which was registered as
Read order 21 rule 106.
Order 21 rule 106. Setting aside orders passed ex parte, etc.
Yes, read it.
In page 161. Setting aside past order ex parte, etc. The number one, the applicant against whom an order is made under sub rule 2 of rule 105 or the opposite party against whom an order is passed ex parte under sub rule 3 of that rule or under sub rule 1 of rule 23 may apply to the court to set aside the order, and if he satisfied the court that there was sufficient cause for his non-appearance when the application was called for hearing, the court shall set aside the order or such terms as to cause otherwise as it thinks fit, and shall appoint a day for further hearing of the application. No order shall be made on an application under sub rule 1 unless notice of the application has been served on the other party. And next provision is an application under sub rule 1 shall be made within 30 days from the date of order, or where in the case of an ex parte order, the notice was not duly served within 30 days from the date when the applicant had knowledge of the order. Now, in this case, my lord, entire anomaly causes due to section.
No, this 106 is applicable only if the
When the matter is fixed for hearing.
hearing and it is dismissed under 105.
Yes, that is the core issue hitting in this case.
105.
But in this case,
No, then read what the appellate court then says.
now appellate court saying in paragraph 8, against the said order dated 29/5/17 of dismissal of the execution case, the decree holders preferred a petition under order 21 rule 106 subsection 1 of CPC read with section 151 CPC, which was numbered as so and so. For restoration of title execution case number so and so, which was registered as Ms. J case number 9/18. The learned in next page, my lord. The learned Munshi Baksa, by the order dated 9/5/19, dismissed the said petition, holding that the petitioner decree holders failed to show sufficient cause for their absence on the date of dismissal. Because we have added some medical prescriptions, which has not been discussed in this order of the civil judge. In the Munshi, while deciding this, our medical prescriptions were analyzed in its order in dated 9/5/17. But in this appellate court's order, it has not been discussed. Anyway, in paragraph 9, the provision of order 21 rule 105 and rule 106 CPC read with as below. 105 hearing of application. The court before which an application under any of the following rules of this order is pending may fix a date for hearing of the application. What we have read out earlier. Provision.
But no such application was under consideration. At what stage the execution case was dismissed?
It was for taking steps. Steps, as we have submitted that steps already taken, but due to amalgamation of districts and jurisdictional question, all that along with other some cases of that jurisdictional area has been transferred to the Baksa court, and being a part of procedure, this case was initiated in fresh. So it was fixed for steps. And we have already taken steps in this regard while it was which was pending before the learned Munshi Brongia. For execution formalities already been completed. It was the new chapter begins there. After transferred the matter case records to the court of learned Munshi Baksa. Thereafter, my lord, here is the provisional discussion. Where on the day fixed or any other day to which hearing may be adjourned, the applicant does not appear when the case is called on for hearing, the court may make an order that the application may be dismissed. Where the applicant appears and the opposite party to whom the notice has been issued by the court does not appear, the court may hear the application ex parte and pass such order as it thinks fit. Explanation. An application referred to in sub rule 1 includes a claim or objection made under rule 858. Now 106 speaks. Setting aside orders passed ex parte, the applicant against whom an order is made under sub rule 2 105 of the opposite party against whom an order is passed ex parte under sub rule 3 of that rule 1 and rule 23 may apply to the court to set aside the order, and if he satisfied the court there was sufficient cause for his non-appearance. When the application was called on for hearing, the court shall set aside the order on such terms as to cause or otherwise as it thinks fit, and shall appoint a day for the further hearing of the application. What is quoted in CPC also earlier we have read out. Further, it is quoted in this order. No order shall be made on an application under sub-rule 1 unless a notice of the application has been served on the other party. An application under sub-rule 1 shall be made within 30 days from the date of the order, or where in the case of ex parte order, the notice was not duly served within 30 days from the date when the applicant had knowledge of the order. Now, in paragraph 10, the Honorable Guwahati High Court in Deonara and Gwala versus
Okay.
Jagadish Pandit reported in so-and-so held that these two rules were inserted by the Code of CPC.
Okay, 105 is not applicable to your case.
Yes,
Therefore, it was rejected.
it was rejected.
Okay. Now,
If it was come within the purview of 105 CPC, then we are entitled for to redress our remedy under section 106 CPC. And
otherwise, where is the remedy?
otherwise, there is no space remedy. There is
And
no
under what-
express provision in the code. If you, I am coming to that aspect. The judgment says, this honorable court says in this order, we are brought into force with effect from 1st February 1977. Rule 105 deals with the hearing of an execution application. Sub-rule 1 of Rule 105 requires the court to fix a date for hearing of an execution application. Sub-clause 2 of this rule provides that if on the date fixed for hearing of the execution application or on application arising out of the execution application or on any other date to which the hearing may be adjourned, the applicant does not appear when the case is called for on hearing, the court may dismiss that application. Similarly, if the other party to whom the notice has been served does not appear, the court may proceed to hear the application ex parte and pass such order as it is proper. Rule 106 empowers the executing court to recall the order of the dismissal passed ex parte, and it provides that the court may set aside the order passed either under subclause 1 of Rule 105 or subclause 2 of Rule 105. If it is satisfied that there was sufficient cause for the non-appearance when the application is called on for hearing, the court may fix a date of a hearing of an execution application if any objection is filed against the same, and if on the date of hearing of the application the decree holder is not present, the application may be rejected. Similarly, if the judgment debtor is not present at the time of hearing of the execution application, the hearing may be done ex parte and suitable orders may be passed in the case after hearing the decree order. Rule 105, however, does not deal with the situation when an execution application is rejected on account of not taking the requisite steps in the case. The order of dismissal or title execution for default on the part of decree holder is not covered under by Rule 105 Code of CPC, because the date was not fixed for hearing of application but was fixed for taking requisite steps in the case. In fact, Rule 106 comes into play when an application was fixed for hearing and the applicant was absent at the time of hearing and the application was therefore rejected. An order not being covered by Rule 105 Order 21 CPC, the application for setting it aside could not be filed under Order 106 of Rule Order 21. There is no other express provision in the Code of CPC dealing with the situation and provision inherent powers of the court under Section 151 of the Code of CPC is invocable. So there is no express provision in the court to deal with such type of situation. Normal practice is that, my lord, when any petition is dismissed before any court of law, whether it may be trial court or high court, if any restoration petition is filed by any applicant with satisfaction of the grounds averred in the said petition, honorable court in lieu of some cause allow that petition to and restore in the interest of substantial justice of the applicants. This is the normal practice in absence of any express provision in the code. So 151 maybe would have been applied, my lord. The Honorable Supreme Court of India in Keshavdhar Chamriya versus so-and-so in AIR.
No, you answer my query. Apart from 105,
Yes.
Rule 105, Order 21, under what circumstances an execution case may be dismissed for default?
Dismissed for default if the judgment
Under what
debtor,
provision?
judgment debtor absence without any steps on that, if the matter was fixed for hearing between the parties.
Under what provision?
Provision is already discussed, my lord.
No, I'm asking you, under what provision? By invoking 141,
No.
then
That provisions are elaborately discussed in which situation. If the matter, any execution petition is fixed for hearing between
No,
the
no.
parties.
my query is section 105, 106 will be applicable only if an application is pending for hearing during execution proceeding under section 105.
Yes.
And same is dismissed for default, then section
Then
106 will
we
come.
invoke.
In the instant case, the situation is totally different.
Different.
It was fixed for taking steps by the decree holder
Yes,
when you remained absent.
yes. But we have,
No. Listen to my query.
Yes,
You remained absent and the court dismissed it for default.
default.
Under what provision it dismissed?
There is, then you lordship have to go through the,
It was not called on for hearing, for not taking steps.
then lordship may, peruse page 70. Page 70, annex 7. It is the order passed in the Miss J case number 9/18.
What is this?
My restoration was dismissed. My restoration application was dismissed.
What was the reasoning?
Reasoning before your lordship, may I read out?
No, you tell me the gist, what happened, why it was rejected.
The learned court below was not satisfied with the reason what we have assigned before it. Because the decree holder number 1 was very seriously ill and the other decree holders accompanied him from the house to hospital. And in
This
support.
petition also was under Order 21 Rule 106.
Yes. Order 21 Rule 106 at page 66. Lordship well founded. I read with 151 of CPC for restoration of TX case number 70. Annex 6. Because as provided in the court that on being satisfied word had been inserted. So learned court below was not satisfied.
You have any authority? Any rulings?
Yes, I am coming to that aspect. Our reason was not satisfied that disbelief that the medical prescriptions are not believed, and so, moreover, in this case, no sections have been elaborately discussed or have been discussed in the input order by the learned civil judge. In the first court order, while rejecting my execution petition, no provisional aspect was discussed.
No, therefore I am putting you a question.
Yes, I am coming to the order of the Madhya Pradesh High Court order.
What it says, what is this?
It says that when there is no express provision in the code, Lordship, kindly come to para 20 of this judgment. 20, para 15 and 20. In paragraph 15.
Yes, para 15.
In the present case, the decree holders had already applied for execution and paid process fees for issuance of a warrant of attachment. It was.
What was the fact? What happened in this case?
In this case, all steps have been taken. We have submitted.
No, in this case which you were citing, the execution case was dismissed.
Yes, this is the crux of this case, what I am relying, paragraph 15.
Okay.
In the present case, the decree holders had already applied for execution and paid process fees for issuance of a warrant of attachment. It was therefore for the court to issue a warrant of attachment of such property as was in possession of the judgment debtors. Submission of the inventory of movable property in possession of the judgment debtors is not necessary under the relevant rules. In case the warrant is returned unexecuted, the decree holders could in their discretion make an application for examination of the judgment debtor under order 41 or could resort to any other mode to recover the decretal amount. Now, operative finding of the court is paragraph 20. Since the dismissal of the execution application on 21/8/1979 was under inherent powers, the application for its restoration will be by invoking inherent powers of the court, and in that even no time limit is prescribed for invoking the inherent powers of the court. So inherent powers may be applicable when there is no express provision in the court. That can be, and from the learned Munsif to civil judge, we have already quoted the read with section 151 of CPC. Though our section may be wrong up to some extent, but section cannot disentitle a party to claim for entitlement of any substantive degree as held by the Honorable Supreme Court on a number of occasions. In B. Hucha Gora's case, section cannot be the issue for to deprive a person for to get substantive rights. For wrong section, quoting a wrong section cannot be the only ground for to reject a claim of a litigant. So what has been done in this case? Only discussing the wrong section. So substantive relief has been.
Do you find out some more authorities? We are fixing it tomorrow. I'll also go through to answer queries posed by me.
Yes.
You answer those queries. Try to find out more authorities.
Then let it be come up on 26.
26, okay,
26.
of this month,
Yes.
Monday. Heard,
April.
Mr.
April.
A. Paul, learned counsel for the petitioner. None has appeared for the respondent on call. During the course of hearing, certain queries were posed to the learned counsel for the petitioner, to which learned counsel submits that he needs some time to reply to the said queries. The prayer is, and hence prays for some time. The prayer is allowed. Let this case be listed again on 26/7/2024 for admission hearing.
Please, Your Lordship.
Yes,
Your Lordship, as per office note dated 19/7/24, services has been completed.
service is complete.
I am appearing for 1, 4, 5 and 6.
Heard, Mr. What is your name?
S.A. Bakhtiar.
S.A. Bakhtiar, learned counsel for the appellant.
Your Lordship, let the matter be posted for hearing.
Also heard, Mr.
D. Chaudhary.
D. Chaudhary, appearing for respondent number 1, 4, 5 and 6. It appears from the office note dated 19/7/2024 that service of notice as regards the other respondents against respondent number 2,
Respondent.
legal heirs of respondent number 2.
They have been impleaded. I has been disposed of.
But you have whether notices have been served on them.
They have received the AD card has been received. AD card has been received. As per the office note dated
Dated
3/10/19.
in IA.
In office note dated in I.
No, but that was for IA only.
Yes.
You have to issue notice in the main second appeal also, because they may not have contested the interlocutory application, but they may contest the second appeal.
Second.
So notice has to go, fresh notices have to. It also appears from record that the appellant has not taken steps for issuance of notice on the substituted respondent, that is respondent number
21-27.
21-27. Let the notice be issued against the said respondent. The appellant shall take steps for issuance of notice to the said respondent through registered post with AD as well as by usual mode within 3 days from the date of this order, returnable after 4 weeks. The trial court record has been received. Stop. List this case again after 4 days.
My lord, in this case, my lord, I have not taken steps, but during pendency of the IA, my lord, one respondent PK Roy appeared, my lord. And their name has not been shown. There is an Wakalatnama also there, my lord. So showing the name of PK Roy, it may be listed, my lord. In I kindly
You have served the copy of notice of RSA to them. I was for condonation of delay.
Yeah.
Delay was condoned, it was registered and again list.
I have served copy. So kindly see the Wakalatnama in the IA, my lord. I have also informed them.
No. Whether in the second appeal any order has been passed.
No, in second appeal, we have to take steps, my lord.
You have to take steps.
Yeah.
You take steps.
But with respect to respondent number 1, my lord,
You
they
can,
informed that they will appear, my lord.
no, if they appear, no issue. Otherwise, you have to take steps.
Remaining respondents, I will take steps, my lord.
And respondent number,
Number 1, they will appear, my lord. They have informed today, they have left the court. That is why they have not come.
okay. Heard Mr. S.K. Ghosh, learned counsel for the appellants. It appears that the respondent number 1 has, no, the counsel for respondent number 1 has informed him that he will be appearing in this case by filing Wakalatnama. Who has informed you? What is the name?
Senior counsel PK Roy, along with A. Chakravarti. Assisted by A. Chakravarti.
Counsel for, should I reflect it
Yeah, it is in Wakalatnama is there, but
in the,
I.
okay. The said counsel within bracket, Mr. P.K. Roy, comma, senior advocate, and Mr.
Assisted by A. Chakravarti.
A. Chakravarti, advocate, have earlier appeared for the respondent number 1 in the interlocutory application filed by the appellant for condonation of delay in this instant regular second appeal. In view of above, the appellant is directed to take fresh steps for issuance of notice to the to the respondents except respondent number 1 within 3 days from the date of this order, returnable after 4 weeks by usual mode as well as by registered post with agent. List according.
My lord, I'll take usual process, my lord. They are performer, actually.
Okay.
Usual process, I'll take.
Registered post for cutting down by usual mode only.
Okay.
May I please your lordship, my lord? In respect of my lord, service of notice by Dosti mode, my lord, I have already taken steps and affidavit is being filed. In respect of respondent number 91, 92 and 12. Paragraph 11, I have specifically stated. Respondent number, my lord, 91, 92 accepted notice.
How
Respondent
many
number,
respondents are there?
no. As many as my lord. 16. All have been served. Only 91, 92 and 12. 91, 92 accepted notice in course of Dosti service and 12 my lord refused. I have made a statement para 11 of my affidavit.
Okay. So you take fresh steps for 12.
12.
12 you take.
But 12
fresh-
my lord, they have refused to accept notice.
Now, what is the consequence of refusal of personal
Well,
service?
Court may not presume that they are
No,
not interested.
No, you go through order 5 rule 9A.
My lord,
If personal service is refused, then you have to take fresh steps.
my lord, as your lordship please.
Third, Mr. A.K. Purkayastha, learned counsel for the appellant, who submits that the appellant has taken steps through Dusty mode for service of notice on respondent number 9 within bracket Roman 1, small Roman 1, comma 9 within bracket small Roman 2 and 12. And the respondent number 91 and 92 have received the notice. However, the respondent number 12 has refused to accept the notice from the petitioner, from the applicant. Sorry, it is civil revision petition. Instead of appellant, mention, right, petitioner. To that effect, the petitioner has also filed an affidavit of compliance of order for effecting the service of notice on the aforesaid respondents through Dusty mode. In view of the affidavit, submitted by the petitioners, the notice issued to respondent number 9-1 and 9-2 through Dusty mode is held to be duly served. Stop. However, in respect of respondent number 12, the petitioner is directed to take fresh steps. Through which mode you will take steps?
Initially, my lord, I have taken step by register post as well as usual my lord courts. My lord notice was returned unsert. Then court person order to take step by Dosti mode. I have taken Dosti mode, my lord notice was
The
returned.
appellant, where he stays, the respondent number 12. Why it was not served through usual mode?
Usual mode already served, my lord. And thereafter, my lord, court has person order, you
No,
got to take.
Usual mode, it was served.
Yes. Notice was duly served as per the direction of the court. I have taken steps. Notice returned unserved. So first 12 and 9-1, 9-2 are concerned.
No, that was my query. Whether notices were served or not. You took steps
My
for
lord.
service,
My
but
lord.
notices were not served on the
Yes, notice was returned unserved.
unserved.
Yes.
So you
9-1,
take
9.
fresh steps
Then, my lord, notice was directed to be taken
through
through
Dusty.
Dosti mode. As your lordship please, my lord, I will take steps
The petitioner is directed to take fresh steps
by register post.
for service of notice on respondent number 12 by registered post with
Madam.
AD as well as through usual mode.
No, register, only register post. Usual mode, my lord,
Both.
both.
Because registered posts may be directed in addition to usual mode.
Madam.
Within 7 days from the
Yes.
date of this order, returnable after 4 weeks.
My lord.
List accordingly
Madam.
after 4 weeks.
There was an interim, my lord, observation.
The interim order shall continue
My lord.
till next date.
My lord. And lordship has made it returnable after 4 weeks.
Now, why it was mentioned, it will not be extended beyond 28/4. In the last order, there is an observation.
Right.
Why?
My lord, because my lord, that was.
What is the interim?
Interim order was that, my lord, court may proceed, but court should not deliver the judgment.
Oh, it is pending at the stage of judgment.
Yes. I don't know now what is the stage. Initially, my lord, matter was fixed for further proceeding for trial. Then I approved this novel court that there was an interim, my lord, order passed against me. Therefore, order is challengeable. Then court, my lord, issued notice and made an observation. And accordingly, my lord, as per the direction of the court, we made an application before the court for adjournment. And that was duly considered by the court.
Okay, then we will give a fixed date.
My lord.
After 4 weeks. Instead of notice is returnable on 22 August. 22 August.
22 August. I don't know. But let it be on 26th August.
26th August.
Or is it 27th?
27th August.
I'll be out of station
27th August. List this case. List this case again on 26th August. 26th.
My lord. And interim order, my lord.
Interim order shall continue till next week.
My lord.
27th.
27th.
Lordship, service is complete on dispute number 6, my lord. Earlier, court was directed to issuance the notice on dispute numbers 1 to 5 and 7, my lord, through paper publication, my lord. Some more time is needed, my lord.
For taking steps for paper
Through
publication.
paper publication. My lord.
Heard Miss L. Sharma, learned counsel for the applicant who seeks some more time for taking steps for publication of the notice
Through paper.
in newspaper as directed by this court by order dated 7/6/2024. The prayer is allowed. Let this case be listed again. On 28th of August 2024, the said date shall be reflected in the notices which are to be published through newspaper publication. 28 August shall be the date mentioned in the notice. List accordingly.
Obliged, my lord. May to your lordship, as per the last order, lordship, I have filed I have taken the Dusty service, lordship, but they refused to accept the notice, lordship. So I have not filed any affidavit. So kindly issue the fresh step or
Fresh steps through which
through as usual process, lordship.
Okay.
The last time I had to file taken step through the registered post, but someone accept the notice, but this is eligible, which was reflected in the order dated 8/5/2024, lordship.
heard Miss
And they
N. Day, learned counsel for the applicant, who submits that in pursuant to the directions of this court by order dated 8/5/2024, the applicant took steps for service of notice on respondent number 1 to 4 by way of Dusty.
Hmm.
However, she submits that the respondents have refused to accept the notice when the said notice were intended to serve on the said respondent. When this when the said notice were tendered to the said respondents. Stop. In view of the submissions made by learned counsel for the petitioner applicant, issue fresh notice to the aforesaid respondents by
As it is.
usual mode. The applicant shall take steps for service of notice on the aforesaid respondents, aforementioned respondent by usual mode within 3 days from the date of this order, returnable after 4 weeks. List according.
has not received your mail.
LCR office notice there. Okay. Heard Miss M. Setia.
No, sir, we are for the respondent number one.
What is your name?
Aspego.
Heard Mr. S. Pegu, learned counsel for the
Appellant.
appellant. Also heard Miss P. Barua, learned counsel appearing for respondent number 1.
One.
Stop. On perusal of the office note dated 27, there is no line to continue. It appears that the records of MEC case number 753/2017 has not yet been received from the Motor Accident Claims Tribunal number 1, Kamrup Metro, Guwahati, as was directed earlier by this court. The registry to issue reminder for the same. List this case again after 4 weeks.
Obligation.
Here we have, it's a testamentary appeal. We have been able to find out the address, Lordship, the new address. Finally, we are allowed to take steps in the new address, Lordship. Earlier address was not specific, it's the same address, but now we have got the specific address. Of all the 3 respondents, they are residing in the same place, Lordship.
Now, whether you have to
I have to take a fresh step, Lordship.
fresh steps and memo of the new memo of respondents carrying their new address shall have to be filed. Otherwise, how will we
Yes,
know
yes, that
to
will be
which
done.
address you are
Yes,
sending?
yes. That will be done, Lordship.
Learned, heard Mr. A. Bhattacharjee, learned counsel for the appellant, who submits that the respondents were not found earlier on the address which is mentioned in the memo of appeal. However, the appellant has been able to find out the new address of all the 3 respondents. And they may be, and the appellant may be accordingly allowed to take steps, fresh steps for issuance of notice in the new address of the respondents. The prayer is allowed. However, the appellant shall furnish a memo of parties, including mentioning therein the new address of the respondents within 3 days from the date of this order, and thereafter shall take steps for issuance of notice to the respondents in their new address by usual mode as well as by registered post with ID, returnable on returnable after 4 weeks. List accordingly.
I have sent one advocate from Guwahati to Jammuria, my lord, for service of notice by Dusty, and it is complete, my lord. After 3 years. On previous occasion, my lord, all the notices were served, but report was not received by the court. So lastly, we served it by
You have-
Dusty.
You have filed an affidavit
Yes, my lord. I have filed an affidavit.
and copy of the notice is also annexed.
I mean, for a respondent, we have filed a Upadar number today.
You are appearing.
Yeah, for respondent.
How many respondents are there?
one.
Only
Only one.
Okay, good. Heard Mr. B.C. Das, learned counsel for the petitioner. Also heard Mr. What is your name?
Anupam Sekia.
Also heard Mr. A. Saikia, who submits that he has been engaged by the respondent to appear in this case, and he will be filing his wakalat
I
number
filed today.
during the course of the day today. You have already filed?
Yeah.
Or
it's in
you will be
process. During the course of the day.
during the
Maybe.
course of the day. Stop. Let this case be listed. What is the matter? Transfer
That's what it is. Yes,
or
that it is,
admission
sir.
hearing. Let this case be listed for admission hearing. On when do you want?
September.
After 4 weeks.
Well, date may be given, my lord, other it will go for.
After 20th August.
In the last week of August on a date to be fixed by registry. Registry will finalize. We are fixing it in the last week of August.
Lordship, I am praying for the pass over the matter for the day.
What is the matter?
Worship, this IA is for stay of execution of the court below order. Worship.
You are praying for adjournment. Why?
Because in case council is not in town.
Worship, I'd like to make some submission, Worship. This IA was filed along with the memorandum of appeal, Worship, apprehending execution, initiation of execution proceeding by.
Whether
the
execution has been filed,
Lordship, not yet filed.
then let us give her time.
Lordship.
Let heard Mr. A. Islam, learned counsel for the petitioner, learned counsel for the appellant, appellant slash learned counsel for the. There is an IA is there. Sudeep, IA to you. In IA. This IA 2922.
Lordship, 290.
Heard Mr. A. Islam, learned counsel for the applicant. Also heard Miss
M. Inky,
M.
Inky,
Inti, who
on behalf of the I. Chaudhary.
who submits that the conducting counsel, Mr. R. Chaudhary,
I. Chaudhary.
Mr. I. Chaudhary is out of station and on that ground prays for an adjournment today. Considering the ground, the prayer is allowed. Let this case be listed after a week, in the next week. After a week on a date to
Date may kindly be fixed.
date to be fixed by registry.
Always.
My lord, in this case, my lord, I'll have to take steps, Dosti service. But I could not able to serve because of the strained relation between husband and wife, my lord. So, in the original FAO, my lord, I have taken steps by registrar as well as by usual process also. But no report has been given by the registry, my lord.
For what this IA is,
I is for stay of that that last order, because of the,
Why it has come up for or acha or await service report?
it is a guardian, actually guardian, for appointment of guardian as well as for custody of the
Child.
child. I am on behalf of mother of the child.
Where do they, where does that, your husband or wife,
Wife,
where your husband stay?
husband stayed in the district of Chirang,
Siram.
Chirang.
Okay.
And I am staying at Borpeta. The child is with me.
Child is with you. Then what happened?
Then
Why this appeal?
before the learned Chirang court, they have filed, the husband filed application for custody of the child. Then I appear.
Your husband,
No, husband filed application.
your wife.
I am wife.
Okay.
Husband filed, that means father of the.
That was allowed.
child. That was allowed. Without considering this aspect, that section 9 of the Guardian and Wards Act, that the Chirang district have no jurisdiction to entertain this guardian petition, because child is in custody in the mother at Borpeta. So Borpeta court is the jurisdictional authority to decide.
Okay. Now let us first serve the notices.
Yes.
Heard Mr. Forgot your name. Eda.
SK.
SK Ghosh. SK Ghosh, learned counsel for the appellant. On perusal of the office note, it appears that the notice is issued to sole respondent by post, by registered post with AD, has not returned back.
I have taken usual process also.
The notices sent through usual mode. In respect of notices sent through usual mode also, the report has not been received. Registry to say send reminder to Munsif number 1. Chirang regarding calling for the report of the notices sent to the respondent through usual mode. Learned counsel for the appellant has submitted that though the notices were directed to be served through dusty mode. However, due to the strained relationship between the appellant and her husband, who is the respondent, the notices could not be, service of notices could not be effected through dusty mode. Therefore, stop. The appellant is therefore directed to take fresh steps for service of notice through registered post with AD. In IA also same. In IA, heard Mr. SK Ghosh, learned counsel for the applicant.
And since in the IA last occasion, stay has been vacated. So I am not pressing the IA.
You are not pressing it.
Yeah.
Dismissed for non-prosecution.
No, not press. I am not pressing this IA. I am withdrawing this IA.
Okay. In I, learned counsel for the applicant slash appellant has submitted that he has instructions from the that the applicant slash appellant does not intend to pursue this interlocutory application. Stop. In view of that, this interlocutory application is dismissed on withdrawal. In main case, they
But in case I will have to take steps.
through registered post.
Yes.
As regards usual mode, we have issues direction to Munsif Sirang. Yes.
May I please address it? Yeah, I for condemning the delay of 11 days. 11 days.
11.
As per office note, upon the respondent number two, notice was served, okay? And respondent number one is answered.
Then respondent number 1, you have to take fresh steps.
Yes. We will take a first step to the chief office addresses, for example, because the address was correct, for example. Address is correct.
Okay. Heard Mr.
People.
P. Bora, learned counsel for the applicant. On perusal of the office note dated 17/5/2024, it appears that the AD card, no, but AD card have been received without signatures. It is not served.
Without signatures.
Without signatures. If you can give the postal tracking report,
Next step.
then we may find out
So did maybe you can.
whether it was served or not. Without signatures.
Because for postal, I think there is. Yes, yes, I collect from the record.
No, you may collect the number from the registry and track it yourself.
Yes.
Learned counsel for the petitioner applicant submits that as the AD card of the notices issued to respondent number 2 has returned without signature of the respondent, he may be allowed to collect the registered number of the he may allow to collect the consignment number of the notices sent through registered post AD so that he may submit the track consignment report on the next day. The prayer is allowed. It also appears from the office note that the notices issued to respondent number 1 has been received back with an endorsement within inverted comma left stop. In view of above, let the petition, in view of above, the petitioner is directed to take fresh steps for issuance of notice to the respondent number 2. Where does he stay, respondent number 2?
Respondent one.
1. Sonitpur.
Respondent number 1 with 3 addresses, main office is for Mumbai. Other
Okay.
general office is Kolkata and other is
Guwahati Rukmini. You take the steps
Yes.
in Guwahati Rukmini address. Fresh steps on respondent number 2. 1. through registered post with AD as well as through usual mode within 3 days from the date of this order, returnable after 4 weeks. Let this case be listed again after 4 weeks.
Highly recommend.
May I please, my lord? My lord, I'm praying for adjournment of this matter for today. Can it be listed on 29, my lord? On Monday, my lord. My senior is out of station, my lord.
Who is your senior?
Mr. SP Chaudhary, my lord.
Any objection?
No, 29 or first, 31st, my lord.
Okay, 31st. Mr.
K. Vishwakarma.
K,
Vishwakarma.
you repeat your title?
Vishwakarma, my lord.
Vishwakarma.
Yes.
Heard Mr. K. Vishwakarma, learned counsel for the applicant who prays for an adjournment on the ground that his senior, Mr. SP Chaudhary, who is the conducting counsel in this case, is out of station. Also heard Mr. AHMR Chaudhary, learned counsel for the respondent who does not object to the said prayer, hence the prayer is allowed. Let this matter be listed listed on 31st of July.
Yes. I oblige, my lord.
None appears for the applicant on call. Let this matter be listed after a week.
May it please the Lordship. Lordship, we have filed this IA for withdrawal of the statutory deposit which we have deposited at the time of filing this appeal. This appeal has been disposed of, Lordship.
Disposed of whether it was allowed or
Allowed.
allowed. The statutory deposit is still there.
Yes, Lordship.
Heard Miss
M. Saikia.
M. Saikia, learned counsel for the applicant. This application has been filed by the applicant / appellant, praying for allowing the applicant / appellant to withdraw the statutory deposit of rupees 25,000, which was deposited by the appellant at the time of filing of the connected MAC appeal number 147/2012. Learned counsel for the applicant has submitted that by order dated
6/8/2012.
6/8/2012, the MAC appeal number 147/2021 has been disposed of. Stop. Has been allowed and disposed of. Stop. In view of above, this application is allowed. The registry of this court is directed to refund the statutory deposit of rupees 25,000 to the applicant / appellant after proper verification.
Obliged,
This interlocutory application is accordingly disposed of.
Obliged, Lordship.
May I please, your Lordship? As per office note dated 27/6/24, unserved notice on behalf of respondent number 1 has been received along with postal remark. Address is out of station, Lordship. So, Lordship, I will take fresh step upon respondent number 1. And Lordship, respondent number 2 already appeared.
Heard Mr. What is your name?
A.R. Das.
A.R. Das, learned counsel for the appellant. Also heard Mr.
M. Talukdar.
M. Talukdar appearing for respondent number 2. Respondent number 2 or 1?
2, Lordship.
2. As per office note dated 27/6/2024, it appears that the notices issued to respondent number 1 has been received back by the registry with postal remark within inverted comma, addressee out of station. Hence return to the sender. Inverted comma close. Stop. In view of the above, the appellant is directed to take fresh steps for issuance of notice to respondent number 1 by registered post with AD as well as by usual mode within 3 days from the date of this order, returnable after 4 weeks. List accordingly.
Obliged.
My please, Lordship. In this case, my lord, we were asked to, my lord, we're allowed to take dusty service, my lord, as well as, my lord, register post officer issued. My lord, it appears, my lord, respondent number 4, my lord, has died, my lord.
Died.
Yes, my lord. And he has got no legal heirs, in fact. He has got no, my lord, children. So we'll have to file an affidavit to that effect, my lord. We
Okay.
tried to serve him also, my lord, we couldn't find, my lord, though actually, my lord, he was residing near, my lord, asked, my lord, but he had left some time back.
And other respondents?
And all the state respondents, my lord.
My lord, then the case, since the sole private respondent is no longer there, and all the remaining respondents are state respondents, then what remains in the case?
Remains because, my lord, there is a conviction, my lord, there is a direction to prosecute them under, my lord, and there is a fine. to be
What
paid.
is the case?
Well, it's a land grabbing case, my lord. It was, my lord, he was held to be a land grabber, my lord, and there was direction to prosecute, my lord, the petitioner, my lord.
This is a civil revision petition.
This is, my lord, initially it was filed, my lord, as a
Petition.
writ petition, my lord, then
Thereafter,
my lord, it was converted to a civil revision petition, my lord.
civil revision.
Holding that the writ petition is not maintainable.
I'm appearing for the
Lordship will
State-
find, my lord, the
state parties.
page 52, my lord, is the, my lord, operative part of the order, my lord. So found to be land grabbers and they are liable to be prosecuted under section 4 of the act, my lord. So that prosecution part remains, my lord. And we have to, my lord, we have been directed to pay a fine of rupees 1 lakh. Of course,
Against-
that of course the respondent says the respondent is expired, there is no question of that may not arise, but then we are liable to be prosecuted. That part, my lord, that part still remains, my lord.
Okay. So this is converted into civil revision
Civil revision petition.
by some judicial order.
Yes, my lord, order passed by some court, my lord. On 26th of, my lord, I think that's well.
Okay, heard Mr. M. Dr. Learned counsel for the petitioner. Also heard Mr. K. Bhattacharjee,
For respondents 2 and 3.
Learned Government Advocate Assam, appearing for respondent number 2 and 3.
For 1.
Also heard Mr. J. Hendick, appearing for respondent number 1. Learned counsel for the petitioner submits that while attempting to effect Dusty service, effect service of notice through Dusty mode on respondent number 4, it came to their notice that respondent number 4 has already expired. Is it correct?
My lord. In fact, my lord, the officer also said when the registered post was notice was sought to be served.
And it is submitted that there is no legal heir of the said respondent. And Learned,
Sole private respondent.
yes,
Respondent 4.
respondent number 4, respondent number 4. Learned counsel for the petitioner submits that the petitioner intends to file an affidavit to bring on record the said fact.
Right.
The prayer is allowed. When?
Should give me 3 weeks time.
Let this
My
case,
lord, one more thing, as a state respondent, because we are concerned about the administration also. Here, the land grabbing case, so the sole person who is was supposed to be the owner, they are saying is dead. So, my lord, we are worried that it is a land grabbing case. So there should no status quo should be maintained, my lord. We should give the word to the court, my lord.
No, there's an interim order, my lord. There's already an interim order, my lord. Only for.
Yes,
for
but
the-
then who is holding that land now? My
The
lord,
land-
we are very worried about that.
That is, no, that is written, my lord.
No, you verify the facts
Yes,
before worrying. First verify the
this
facts.
is very serious, my lord, because
No, but facts are, it appears that you are unaware of the fact. Who is holding the land, you don't know.
yes, the papers are saying that I read today that nobody is actually in possession of the land. So that is very serious, my lord, because the person who is, we know to be the owner is dead now. And he is saying that he does not have a
No,
legal.
my lord,
claim.
my learned friend is not, my lord, aware of the brief, my lord. What has happened, this is a family property, my lord. So he is not actually the owner. What happened, my lord, even if he is the owner, my lord, then they will become the legal heirs because it's a family property belong to their father. Now, during the lifetime, my lord, there's a dispute with the brothers, my lord. So anyway, my lord, that is a different issue, my lord. My lord, my learned friend need not be worried about the, my lord, because this is already, my lord, paragraph, last order lordship will see, my lord, at page, my lord, 22/5/2024, my lord, there's an interim order also, my lord. The, my lord, stays with regard to, my lord, the proceedings, my lord, being stopped, my lord. We are not saying that we are in possession, my lord. That's take appropriate steps for handing over possession to the scheduled respondent 4. So now that, my lord,
That is not state.
that is not state, my lord. But since he's expired, my lord, now we have to file an affidavit to that effect.
Whether there was a specific direction by this court to hand over possession to respondent number 4.
Yes, my lord, because it was directed, my lord, that as such a learned district court, my lord, page
Oh.
4 of that order.
Okay, let us. Okay, we'll see that. Now, in whose possession land is there?
Well, actually, we claim that we are not in possession of the land. My lord. We had claimed that. So therefore, that's the reason, my lord, why it was directed, my lord, that the steps be taken over for handing over possession to the respondent 4. Now, since he has also expired, my lord, but then since it's a family property, my lord, now of course the question will arise because in a Mohammedan law, even though the brothers can also be legal heirs, my lord. So that is another question that will remain open. So therefore, there is no contesting party as such at this moment. Legal, but I have legal. Share. Thank you. Yeah, thank you. Thank you. So things are a little different now.
My lord may add a sentence that the status quo be maintained. Because that may save a lot of trouble later on.
But without knowing what is the status.
Yes, but then later on, they will harass the courts, they will harass the officers, my
That's a
lord,
court, man. That's a court.
and waste all the time, my lord.
They have created the situation by not, my lord, forming the appellate tribunals, my lord. That's why, my lord, all these troubles are taking place, my lord. The act has been, my lord, brought in. No appellate tribunal has been, my lord. In fact, my lord, there is a direction, perhaps not in this case. There's a direction, my lord, from the state to, my lord, tell this court, honorable court, my lord, as to whether what is the status of, my lord, the formation of the appellate tribunals, my lord. Under the Land Grabbing Act, my lord, there's a provision for appeal. Now the appellate tribunals are not there, my lord. My lord, 227 reliefs, 226, 227 reliefs are very limited, my lord.
Okay, but then some legal representative of the deceased may be there. As you are saying that brothers.
Brother is the petitioner, it's the complainant, the petitioner, my lord. Yeah, the appellant, the petitioner himself is the brother, my lord. 3 brothers were there, my lord. 2 of, including the respondent. Petitioner is one of them. The second one had already died. And this is the 3rd brother, my lord.
Who will inherit his property?
Now, my lord, apparently this person is going to inherit, my lord, since there's no legal issue. Then I'll file an affidavit to the effect. That's why.
Let him file affidavit
Yes, that's why I'll file the affidavit.
after 3 weeks.
My-
May it please your lordship. Question is a transfer petition. I'm the wife, my lord, and my husband has filed a has filed a divorce suit in Vishwanath Sailali, my lord. Now I am residing in Nagaon with my child. I filed a maintenance case, I filed a DV case, and I filed a complaint case for return of the stolen properties. Now in the maintenance case, there's an order of payment of 5,000 rupees, which he is not paying.
These cases are filed where? At Nagaon?
Divorce, my cases are filed in Nagaon, my lord. I am residing in Nagaon with my child. My cases are in Nagaon. In DV case also, now he has stopped appearing at the stage of defense evidence, my lord. And in the CR case, warrant of arrest has been issued against him. Now thereafter, he has gone and he is residing in Biswanath Charari and he has filed a divorce suit in Biswanath Charari. So we are filing a transfer petition, my lord. First ground, my lord, I am residing in Nagaon. I have
Whether
no-
service is complete.
But on the last date, my lord, we've taken steps, my lord. Service report is not awaited, but in the last order, it has been reflected that the issue of stay will be considered today, my lord.
Okay.
Because we took up the matter came up in vacation, my lord. So it is directed that it would be taken up today.
Have
We
you
have
taken steps?
My lord, we have taken steps not to Dusty, my lord, because of the reason that our relationships are
Strained
strained.
relationship.
And there is also threat. We have also mentioned it in our petition, my lord. We have taken it through registered post, my lord. That is awaited, my lord.
Heard
only-
Mr. S. Nawaz, learned counsel for the petitioner. On perusal of the office note dated 17/7/24, it appears that neither the AD card nor the unserved notice sent to the respondent, sole respondent, has been received by the registry. It appears that though the service of notice was also permitted through Dusty mode. Stop, however, learned counsel for the petitioner submits that due to the strained relationship between the petitioner and her husband, who is the respondent in this case, the service of notice could not be effected through Dusty mode. Now, what will you do regarding service?
My lord,
Await
we'll await, my lord.
Okay. By usual mode also, whether it was sent? No.
No, my lord, registered post.
No, it was sent. There was an order.
My lord, in that case, we have taken steps accordingly, my lord. Only Dusty we have not taken.
Await service report. Learned counsel for the petitioner has submitted that the petitioner has filed 3 cases against the respondent at Nagaon where she resides, namely a maintenance case.
MR case number 22 of 14.
Maintenance case under section 125 CRPC, which was registered as MR case number
22 of 14.
22 of 14, a case under Protection of Women from Domestic Violence Act, which was registered as
DV case number 195 of 19.
as well as
A complaint case, my lord.
a complaint case which has been registered as
CR case number 102 of 2016.
CR case number 102 of 2016. It is also submitted by learned counsel for the petitioner that in the MR case as well as in DV case.
In the MR case, my lord, already order has been passed for payment of rupees 5,000, which he has not been paying regularly.
In the MR case number so and so, the court has already passed an order for payment of rupees 5,000 as
Maintenance, man. Final maintenance.
disposed of
Disposed of. Execution is pending, but
as maintenance. However, the respondent has not paid the said amount
regularly, not.
regularly. And in DV case, the court has issued,
In DV case, my lord, the court has closed their defense evidence, my lord, because of their failure, my lord.
and in which case warrant has been issued.
Warrant has been issued in the CR case, my lord.
In DV case, the court has closed the defense evidence as well as in the CR case number so and so, due to non-appearance of the respondent, the court has issued non-bailable warrant of arrest against the respondent. It is submitted that even after knowing that the respondent that the petitioner resides at Nagaon,
With her child.
at Dhing in Nagaon district, in her
Parental home.
in her maternal home, the respondent has filed the divorce suit which was registered as title suit within bracket matrimonial number 31/2022 23 before the
District
Court of
Court.
Learned Additional District Judge Vishwanath,
Filed before district judge minus subsequently transferred to additional.
filed before District Judge which has been transferred to the Court of Learned Additional District Judge Vishwanath. Learned Counsel for the applicant submits that till the next returnable date, the proceeding of the title suit within bracket matrimonial number 31/23 may be stayed. At which stage it is pending?
For objection, my lord. We have on the last occasion when there was no stay, my lord, because the last date opportunity was granted to us, we filed our WS, my lord. Now it is pending on, fixed on 3/9/24 for objection.
And state case is fixed for 3/9/2023, 2024 for filing objection. Stop. In view of the submissions made by learned counsel for the petitioner as discussed herein above, further proceeding of TS number
31 of 20.
31 of 2023 pending before the Court of Learned Additional District Judge Vishwanath is hereby stayed till next returnable date. List accordingly.
Deeply obliged, my lord. May I please, your lordship? In this case, I am for the petitioner, and we took step upon the respondent, all the respondents with register post with AD, and as per office note dated 22/7/24, answer of notice has been received for respondent number 1, as he was out of session for 10 days, and no notice has been received for respondent number 2 and 3. Finally, fresh notice may be.
Fresh notice.
Yes.
Heard, Mr.
N. Thakuria for S. Sharma.
N. Thakuria, learned counsel for the petitioner. It appears from office note dated 22/7/2024 that the answer notices issued to respondent number 1 has been received back by the registry with an endorsement within inverted comma, addressee out of station for last 10 days. Stop, RTS, inverted comma close. And neither the AD card nor answer notices have been received in respect of other respondents. In view of above, learned counsel for the petitioner prays for allowing the petitioner to take fresh steps for issuance of notice on all the respondents. The prayer is allowed. The petitioner shall take fresh steps for issuance of notice on all the respondents by registered post with AD as well as by usual mode within 3 days from the date of this order, returnable after 4 weeks. Let this case be listed after 4 weeks.
My pleasure, Lordship. In this case, I have submitted affidavit regarding dusty service, Lordship, 115/11/2024, and the sole respondent, and they have appeared also.
You have
Lordship, we have entire appearance, Lordship, we have to file our reply, Lordship, may grant us 3 weeks time, Lordship.
heard Mr. S.D. Purkayastha, learned counsel for the petitioner, also heard Mr. B. Chakravarti, learned counsel for the sole respondent, who submits that the respondent intends to file a written objection and seeks 3 weeks time for the same. The prayer is allowed. Let this any stay is there? No.
No, it is subject to outcome, Lordship.
Okay. Let this case be listed again after 3 weeks.
A date may be fixed because, Lordship,
3 weeks on a date to be fixed by registry.
Obliged.
May plead your lordship. As per last order, lordship, I have taken dusty service upon all the respondents, lordship, and today I have filed an affidavit, lordship, in this regard, lordship. May I pray, lordship, kindly take up the matter next week along with that affidavit, lordship.
Okay. Third, Ms. P. Bhattacharya, learned counsel for the petitioner, who submits that in pursuant to the direction of this court dated 27/6/2024, the petitioner has taken steps for issuance of service, for issuance of notice, for service of notice on the, how many respondents are there?
Lordship, there are 5 respondents.
On all the respondent to Dusty Mode. And the notices have been effected, have been served through Dusty Mode. And in that regard, an affidavit of compliance has also been filed today by the petitioner. However, same is not on record. Stop. Therefore, let the affidavit of compliance filed by the petitioner be called on record, and let this case be listed
On 2019, possible, this is the injunction matter, lordship. That's
on
some-
29/7/2024.
Obliged.
Here register, as well as Dusty is taken, registered it's appear.
Correspondent one.
So
How many respondents are there?
one respondent, this
Okay.
one plaintiff, he's appeared. So on the same issue.
Other respondents have not appeared.
No. Plaintiff is one and defendant will want to say that they are not necessary party. So order 1 rule 10(2) petition was rejected, that no order is passed, but they are unnecessary. They are from it. So that is why the revision is filed. So it may be hard since the plaintiff is appeared and
No, against other respondents?
other respondents are necessary party. One place 135 is the petition. That is the order 1.
No, no.
Only
Whether service is complete or not,
complete. Justice service, we have taken an affidavit is
on all respondents.
all respondent not required. They are defendant.
Actually,
Defendant 1 and 2 say that we are not necessary party. This is our number deleted.
No.
Plaintiff is 1 only.
the respondent number
Others
3
are-
is the only contesting defendant.
Yes, the contestant they have appeared.
But the defendant number 3 is represented by his legal heirs.
So 1 and 2.
He has
say-
not appeared.
1 and 2,
Yes, 1 and 2 say filed the miscase that our name should be deleted, and plaintiff is the contesting party. So plaintiff is appeared today. By the stream mode, we have filed the affidavit.
but have you taken steps for,
But page 135, kindly see your lordship. Who is the part, main petition, miscase petition, 134. And actual 11. This is application order 1, rule 10.
no, at
Here
least,
versus only joined the, he is the only contesting party, that is why.
no, Mr. Burwa, you have made them party respondent in this revision petition. At least notices have to go. Then they have a choice not to appear. After service of notice,
Actually, that is our wrongly, we have made them party because they have nothing to say.
then you file a petition for striking out their name.
So but orally, I am present.
No, nothing orally. Either you take steps on them and wait for service of notice, or file an IA.
Then your lordship be 10 days time by Dosti mode, I can give the
Yes.
affidavit.
Then if they don't choose to appear, then
Yes,
we may proceed.
If the technicalities is there though, I can take a Dosti mode.
You have to follow,
Yes, Dosti mode,
because tomorrow they may appear and say that it was heard on our back.
actually page 135, only one opposite party. That is the reason, and others we made party.
Heard Mr. M.J. Burwa, learned counsel for the, because there is a specific order
Yes,
to take steps on all the respondents to registered post with AD. Have you taken steps?
no, I
That,
have take only one.
that has to be complied with when there is an order of this
So
court.
I have filed a
petition to striking order. That may be done.
No, you are fluctuating your stand.
Actually, that was our mistake. They have nothing to do with this. We are all defendants.
No, no, Mr. Burma. When court has directed you to take steps,
I understood that.
if you don't take steps, your case will be maybe dismissed on that ground also. That you have not complied with the
Yes.
directions of the.
So your lordship may allow the dosti also on to other respondents.
Yes, Mr. M.J. Burwa, learned counsel for the petitioner. Heard Mr. M.J. Burwa, learned counsel for the petitioner. Also heard Mr.
BS Decalogy.
P.S. Dekar, learned counsel for the
Respondent number one.
respondent number,
One.
respondent number 1. As regards other respondents, it appears that notices have not been issued. No, as regards other respondent, it appears that the petitioner has not taken steps for issuance of notice on the said respondent. Stop. The petitioner is directed to take steps for issuance of notice on the
Pro forma respondents. They are pro forma.
respondent number 2 and 3
All are pro forma. The page 5 pro forma.
within bracket pro forma respondent by registered post with AD
As well as dusty maybe. There should be urgency is there. That is.
and usual mode as well as by usual mode. The petitioner is also allowed to effect the service of notice on the said respondents through dusty mode. In case of the service of respondent is effected through dusty mode, the petitioner shall file an affidavit of compliance on the next date fixed.
A short date may be given.
Let this case be listed again on when
My lord, short date or 10 days after. that.
suggested date.
My lord, August 5. 4, 5.
Is it okay?
Yes.
5th August, 5th August.
Obliged.
May please, your lordship. Let me kindly take up IA 1600 of 2024, lordship.
Lordship, may I please your lordship? I pray for adjournment, lordship. Leading engaged counsel for respondent number 1, Mr. B. Bora is not keeping well today, lordship. So list the matter after a week, lordship.
What is this I for?
Lordship, I want to repair my shop, lordship. This is a welding shop, lordship. It is a Charlie house with bamboo wall and bamboo, lordship, post, lordship. I want to repair that house, lordship. That's why I filed this application, lordship.
And what is the main case?
In case, lordship, this is the second appeal, lordship. Suit is for eviction and right title interest.
You are the,
I was the defendant, lordship. And this
you
is
are to be evicted.
Yes, lordship, but in that suit premises, I am running one welding shop, lordship. This is the only source of my income, lordship. So I want to just repair that house.
No, but there is a decree against you.
Yes, that is correct,
Then
lordship.
how you can insist?
Till disposal of this appeal, lordship, I have to run that.
Is there any stay on execution?
Yes, there is a stay.
Stays there?
Yes.
Then let them repair.
Lordship, after a week, the matter may be listed, lordship.
Okay, let
They're on 29th, lordship, because I have some ideas on 29th.
heard Miss P. Bhattacharya, learned counsel for the applicant. Also heard Mr.
P. Dekar
P. Dekar.
for
Sir,
respondent 1.
for respondent number 1 and
For the respondent number 2, my lord.
Mr.
HP Dwalaman.
H.P. Gwala appearing for respondent number 2. Learned counsel for respondent number 1 prays for an adjournment on the ground that who is not there?
D. Bora.
Mr. D. Bora, who is the conducting counsel for respondent number
1.
1, is not keeping
Keeping
well.
well.
Considering the grounds made by learned, considering the ground shown by the learned counsel for the respondent number 1, the prayer is allowed. Let this case be listed again on
29th. sir.
29/6, 29/7.
Obliged.
Okay.
May it please, your lordship.
Your Lordship, this I is for refund of statutory amount of rupees 25,000 which the insurance company has deposited before the registry of this honorable court.
What happened to, you were appellant?
Yes, Your Lordship.
What happened to appeal?
Your Lordship, it was disposed of. As
Allowed
per
or dis-
order, allow for-
Where is the order?
Your Lordship, order is 18/1/2024. In the MSC appeal, it will be there.
So the MSc appeal. Third, Mr. S. Datta, learned counsel for the petitioner. Heridio. Third, Mr. S. Datta, learned counsel for the petitioner. This application, this interlocutory application has been filed by the applicant slash appellant for paying for refund of the statutory deposit of 25,000, which was deposited by the appellant at the time of filing of MSc appeal number 179/2019. Learned counsel for the applicant has submitted that the said appeal, the aforesaid appeal has been disposed of by this court by order dated
18/1/2024.
18/1/2022. The said appeal was allowed. What was the fate?
Your Lordship, I'm not having any idea regarding it. Because
Therefore, in such petition, you should annex the copy of the judgment.
Yes, Your Lordship, but Your Lordship, I'm not the engaged counsel. Actually, engaged counsel is Miss M. Chaudhary. I'm only having the copy of I.
Where is the judgment?
Your Lordship, the matter was heard on 11/1/2024.
And when it was disposed of?
18/1/2024.
Kabir, your judgments also. Atasini.
MSc April 179 of 2009.
Dated
18/1/2024.
Itu নহয়, itu judgment কিতাপ থাকে wrongly in experts. ঠিক Yes, sir.
Order to nine.
Stop. What was the last line? No. I have perused the judgment and order dated 18/1/2024. It appears that the said appeal was dismissed by this court. Stop. In view of disposal of the appeal, the statutory deposit of 25,000 deposited by the applicant slash appellant shall have to be returned back. And accordingly, the registry of this court is directed to refund the statutory deposit of 25,000 to the appellant slash applicant after proper verification. This interlocutory application is accordingly disposed of.
Much. This is an IA for condonation of delay, my lord. There is a connected order passed under section 9 by the district general, which is challenged. My lord, we have filed an application for condonation of delay. So in this case, notice we do.
Heard Mr. H. Gupta, learned counsel for the applicant. This application under under what provision you have filed this?
No, under the, it's a 227 application or under the Guwahati High Court rules.
This application has been filed. This is a civil revision of 227 application. This revision petition is under Article
227.
227. What is the period of limitation?
My lord, would also have it, my lord, 30 days, my lord.
No, for a 227 application, what is the period of limitation?
My lord,
That is my query. Where is the provision?
my lord, ought to have been filed in the 90 days, my lord, because in 90 days we ought to have challenged.
No, you tell me the provision.
My lord,
We'll take it up after some time.
my lord,
You go through the provision.
my lord.
Pisot, all of Pisot, Martin. Same matter.
Same, sir.
Okay.
May I please your lordship? I am appearing for appellant lordship. There is lordship, their earlier lordship matter was disposed of by an agreement before the mediator lordship, but the respondent did not.
We will restore. 1719 is for restoration of Mat Appeal 19.
Yes, reopen of 19. Yes.
Only the additional reasons would be that as there was a clause in the deed of their agreement, therefore
Clause 9.
it gets restored.
No.
So I'll pass orders in chambers.
Lordship.
1719 is also disposed of.
Now the
Mat Appeal is restored to file. It will be heard on next date.
Lordship. Deeply obliged.
Oh, 1719 is not listed today.
Oh, Lordship. Let it come next week. Next week.
Let it 1719 next week.
Lordship.
These two we are disposed.
Okay.
Okay.
That can be disposed of. Both
The registry is directed to list the directed to restore the IA number 1719/2019 and lists it along with Mat Appeal number 19/2018 in the next week on a date to be fixed by registry.
Deeply obliged.
May I have your lordship's indulgence one? I'm sorry, the time is up.
Item
Item number 50.
ভিতৰত দিব লাগিব অলপ corrections থাকিব
Item number 50, my lord, 50. There's an interim order which needs to be extended. If that
Who
can
is
be done.
appearing for the other side?
Item number 50, yes, 50.
Extension, no issue.
And if until further orders, my lord, and if the records can be called for on the next date, maybe it can be heard also, disposed of also.
Item number 50.
50,
Item number 50.
50.
50. This matter could not be heard due to paucity of time. However, the interim order granted earlier shall
Continue.
be extended until next date.
My next date, like this kind of situation happens, my lord.
It will always happen.
And my lord, if the LCR can be called for, my lord.
The trial court record may be called for, registry to issue requisition for, registry to take steps for requisitioning the trial court record. List this matter after a week, after 2 weeks, on a date to be fixed by registry.
I'm grateful. I'm very grateful.
Item 51, but interim may continue.
No, wherever there is interim, it will continue.
Yes, sir. Item number 49.
49, 50.
And 52 also, my lord. 47 also, lords.
Interim is there
Yes, lords.
and others will be left over. Where there is no interim, no orders shall be passed.
46 was, my lord, we call after some time.
Tomorrow,
Fix the date.
45, 46, you are ready with the answer.
Yes, yes, I am ready, my lord. In fact, my lord, we have filed the petition in Article 227 initially. But my lord, there was an objection from the registry. We had to add section 115. But my lord, under the unlawful act, the act, there is no provision. Once the appeal is decided by the district judge, and under the, my lord, Public Premises Act, the order becomes final. So only remedy is under 227.
Okay.
So, my lord, in fact, that was not required, but since.
Now, what is the limitation of 227?
227, there is no limit.
No limitation.
Since 115 was added, my lord, registry instructed that we should file an ISO to file it. In fact,
No, 115 and 227 will not go together.
we will not go together.
Either 115 or
Yeah,
227.
there is a note, my lord, we tried to argue, but.
Okay, we'll take it up after, in the next week.
My lord, said it.
Suggested it.
No, any date, my lord.
Item 45, 46, date at
Next week.
Tuesday. they give. Okay, Tuesday.
Lordship, item 48 interim to continue.
48 interim shall continue.
Maybe fixing admission hearing.
48,
48.
okay.
After 2 weeks, your lordship.
48 interim shall continue. Place this matter for admission hearing after 2 weeks.
Your lordship, 3 weeks, because
After 3 weeks.
3 weeks. Oblige, your lordship.